Hello, everyone. Welcome to the Future of Speech Online 2025, the age of constitutional evasion, jawboning, and other forms of government pressure to control private speech. We're very excited you could join us. Just as a heads up, we are recording and live streaming today's session on CDT's YouTube page. So if you have to pop out to another meeting, that's okay. You can catch what you missed online. Please also note that this event is on the record. For those of you who don't know me, I'm Kate Ruan. I'm the director of CDT's Free Expression Project. We're scheduled to go from noon until 3 p.m. Eastern today and tomorrow, and our speaker schedules are tight, so we're going to do our best to stick to that schedule. If you have questions, please get them in early. We're taking audience questions throughout the session with the exception of the fireside chat. If you're connecting through Zoom webinar, you can use the Q&A function at the bottom of the window. If you're following on the live stream, you can submit questions via email at questions@cdt.org or via X or Blue Sky using CDT questions, hashtag FOSO2025, and @SendDemTech. CDT's comms team will be monitoring these channels and will pass those questions to our panelists. We are delighted to welcome a very broad audience today, and we would remind all speakers and participants to try and keep our language as accessible and understandable as possible to allow non-experts to follow along more easily. I would now like to introduce Alexandra Reed-Givens, the CEO of the Center for Democracy and Technology, for some welcoming remarks.
Thanks so much, Kate, and hi, everyone. Welcome to the 2025 Future of Speech Online Conference. We're delighted to bring together this community of legal experts, technologists, practitioners, and public servants for our annual event focused on the future of online speech. At CDT, we believe that the freedom to express ourselves and to access information is the foundation of democracy. Right now, that foundation is facing exceptional challenges in the US and around the world. This year's conference explores one of the central challenges, the way governments use informal pressure, regulatory threats, and coercive tactics to shape what can be said online, in classrooms, in research, and in public debate. The practice of jawboning isn't new, but we're seeing its effects in sharp relief and at an unprecedented level here in the US. This year, the administration has taken action after action to chill and suppress speech that it disagrees with. Students and non-citizens have been targeted for deportation or had their legal status revoked for engaging in lawful political advocacy, sometimes for nothing more than social media posts critical of government policy. Journalists, researchers, universities, and civil society organizations have faced intimidation, investigations, or lost essential funding. Meanwhile, the administration is openly leveraging its regulatory authority to pressure broadcasters and social media companies' editorial choices and content moderation policies. These steps are happening at the same time that the administration and congressional leaders invoke the mantle of free speech and criticize government jawboning. So at CDT, we want to call the question, what does it mean to stand for the First Amendment at this critical time? What are the contours of jawboning, especially in light of recent Supreme Court cases on this issue? And how are the actions I've described impacting people's free expression rights in practice? Can we agree that such flaunting of the First Amendment cannot stand? As FOSO always seeks to do, this conference will combine analysis of the legal and constitutional issues at stake while exploring their real-world implications. As you'll hear from some of our speakers, the actions we're seeing are having a dramatic effect for students who censor themselves rather than risk deportation, teachers who are avoiding controversial topics, journalists who hesitate to publish stories, and researchers who can no longer study the ways that social media platforms shape public discourse because of sustained politicized attacks on this academic field. We'll also look at some of the newly emerging issues in this space. One we're greatly focused on at CDT is how AI will further change our information landscape and public discourse in the years to come. As users move to AI-generated summaries instead of search results, to discussions with AI chatbots instead of browsing the web, our mediated information environment will soon be more mediated than ever before. Governments are rightly asking questions about children's safety and the mental health effects of highly engaging conversational AI. But what are the First Amendment and free expression implications when governments try to regulate or influence AI outputs or engage on what AI systems can or cannot say? In another emerging area, we'll look at the significant ramp up in social media monitoring by US and foreign governments, who are increasingly using automated content detection tools to monitor people's online speech and take actions against them, with extreme consequences for free speech and for user privacy. Throughout, you'll hear from a diverse group of academics, advocates, technical experts, and more. As we begin this conference, I'll note the bipartisan nature of our inquiry, which impacts anyone who cares about the First Amendment, whether you're on the left or the right. Defending free speech has never been about defending only the speech you like. It's about protecting the right to speak and access information without the uniquely heavy weight of government interference, and preserving a robust, open space for public debate. Thank you to the Stand Together Trust for supporting this conference, to the CDT team for all of their work on this event, and to our wonderful speakers for what I know will be a great discussion. Now, Kate, back to you.
Thank you, Alex. Now, to begin with the legal framework of jawboning, what are the principles that govern here, and how do we make them real? To explore those questions and more, we are joined for a fireside chat between Genevieve Lakier of the University of Chicago Law School and Derek Baumbauer of the University of Florida Levin College of Law, moderated by Daphne Keller of Stanford Law School. As a brief reminder for the fireside chat, we will not be taking audience questions. And with that, I will turn it over to Daphne.
Thank you so much, Kate, and thank you, Alex, and everyone at CDT for putting together this event, which is always excellent. So we are here today to talk about jawboning, and I actually do not yet see my fireside chatters. So if Derek, hi, Derek, and welcome, Derek and Genevieve. We're going to talk about jawboning, which is a term basically nobody knew as recently as maybe 5 years ago. I will loosely define jawboning as the exertion of government pressure to suppress speech through non-legislative channels or through channels that are not the clear legal authority of the state actor, but rather some kind of backroom or back channel or non-official communication. And our speakers may add to that definition. I want to start by asking a question of Derek about how we got here. Because when I was researching and writing about jawboning in 2018, Derek, your article was kind of the only thing out there. And now we seem to have a hearing on the topic every week. Indeed, we are going to have a hearing tomorrow with witnesses, including from FIRE and from Public Knowledge testifying. So how did we get here? What happened between when you were writing and now to make this such a focus for so many people?
It's a great question. First, thanks to CDT for having me, and to you for moderating, and for Genevieve for being a co-panelist. I guess that my great terror is that perhaps somebody actually did read a law review article, which I think almost never happens. And I guess that perhaps this was inevitable given the rise of the power of social media platforms, and also given that if we think about jawboning in a slightly broader context than just pressure on social media platforms, it turns out to be a sort of really shockingly and frighteningly easy way to do things. You don't have to issue an executive order, engage in notice and comment rulemaking, go through the legislative process. All it takes is a willingness to essentially leverage the transaction costs, right? The pain that congressional committees, as with Senator Cruz's committee or Representative Jordan's committee, can inflict, or that executive agencies can inflict, just by quote unquote asking questions, right? By issuing demands, by requiring people to show up, based on subpoenas and so forth, and that can have a remarkably powerful effect. And so I think that in many ways, perhaps the rise of jawboning was inevitable. It only took, somebody to be clever enough to realize that they could put pressure on actors that they wanted to target, and in particular, speech intermediaries, just by kind of leveraging the transaction costs of the administrative state. and with the importance of social media. And then I think also another thing that happened is just there's been some degradation in the norms of how government acts. And I would argue that this is particularly true from 2016 through 2020, not to be partisan about it. There were certain things that government in the past simply would not do as a matter of ethics. And I think that those habits have collapsed.
Genevieve, is there anything you would add to that description? I know that in your writing, you have talked about a broader range of cases than I think Derek and I had focused on. And so maybe you would see a history of more jawboning going on all along. What is the story as you see it?
Yeah, I mean, I think jawboning is the great unrecognized free speech danger, free speech problem in American history. We see from the beginning of the 20th century reports, including in the cases, but also not in the cases, of police officials and prosecutors and local mayors doing exactly what Derek was talking about, wielding the power of the administrative state to put pressure on speech intermediaries and speakers. And here we're talking about a wide range of actors, not social media platforms, they hadn't been invented, but billboard companies and newspapers and booksellers and you name it, to suppress or take down speech that they didn't like. And so I think that there is, in fact, a long history of jawboning. You know, my general view of government power is that the government actors like to suppress speech that they don't like and are going to use whatever tools are available to them to do so. And once you see the emergence of the modern First Amendment doctrine, which imposes increasingly significant constraints on the government's ability to just directly regulate speech, we see the beginning of this effort at constitutional evasion. So this is most notable in the early 20th century when it comes to obscenity, when you start to see constitutional protection for smutty and sexually explicit materials, you start to see pressure to evade those rules by prosecutors and police. But then this proceeds throughout the 20th century. I think Nixon really wanted to put a lot of pressure on the newspapers and broadcasters about to suppress speech that was antagonistic to him. And so I think we should think of it as a familiar and attractive tool for government officials who want to control the information environment. I think what changed is, on the one hand, with the rise of the social media platforms, it became, perhaps because so much more ordinary public speech was occurring on the social media platforms, its effects began to be so much more pervasive, and it became more politicized. I think there's a long bipartisan tradition of jawboning in the country, but with the COVID pandemic and with the Biden administration's efforts to get the social media platforms to suppress what they considered to be COVID misinformation, it became a lightning rod. It became a sign of the Democrats' and I think the woke left censorial tendencies. And so I think although we've had decades and decades of jawboning, and we don't know how much jawboning we've had actually, because a lot of jawboning happens in secret. So the actual amount of jawboning in American history is so far an undiscovered question. With the jawboning of the social media platforms, all of a sudden this becomes something that it is worth politicizing. And jawboning for the first time goes onto the front page of the newspapers, generating a lot more attention and concern about it, which I think is good. But at the same time, I agree with Derek that the norms around the relationship between the government and private speech intermediaries that perhaps to some degree limited or put into the shadows the ways in which the government put pressure on platforms and other media institutions, maybe those are degrading as well. And so we're seeing, certainly under the Trump administration, much more aggressive jawboning than we've ever seen before, or maybe just much more public jawboning. We don't know what we don't know.
So I'd love to explore how different it is once platforms enter the picture. You know, is the jawboning or the government pressure on a Facebook or a YouTube meaningfully different from the kind of government pressure that might have occurred in past years with Nixon pressuring newspapers or with legal pressures on bookstores? Derek, do you want to kick off talking about that?
Gladly. So I think that the major difference is simply incentives. And one of the things that makes this meaningfully different is that, for example, if we think about pressure on CBS, right, or pressure on the broadcast networks during the Vietnam War, it was the content that had been in some sense created or authored by, if not the networks themselves, then by network employees or by people, with whom they had a contractual relationship. Whereas with social media platforms, the platforms have a great deal of interest in having popular and attractive content, but they have almost no investment in any particular piece of content. And so the incentive structure is just a little bit different, right? It is at some level, if Walter Cronkite doesn't say something on the evening news, that affects Cronkite's reputation and it affects the network's reputation. If Facebook takes something down, well, perhaps they look like they're acting in a censorial capacity, but it's not their content. And so I think that that set of different incentives makes a big difference in that it makes social media networks or internet platforms more generally um, much more willing structurally to engage or to respond to jawboning, right? They're happier to censor things just because they have less incentive to let it stay up and more incentive to sort of go along gracefully. And I also wonder too, with internet platforms, whether, as odd as this sounds, the regulatory structures that govern them are in some senses less well defined. So we do have Section 230, and we have the FCC and a number of other things. But there are, Section 230 is sort of increasingly kind of riddled with holes. It's becoming Swiss cheese-like. And there are a variety of actors who haven't hesitated to go after the platforms. Whereas with newspapers, we have a very long tradition and history of judicial precedent about who can not regulate newspapers. Same thing with television stations. And so forth. So I do wonder about the structural effects, and also I have the sense just from our past work that Genevieve might feel somewhat differently. So I feel like I should pipe down and let her chime in.
Well, I mean, I agree that the social media platforms have a different relationship to the speech that flows in the platforms than newspapers and broadcasters, and that's one factor, that's one element that I think determines the extent to which they're willing to defend against government pressure. And I guess we should say the problem in all of these contexts is that there isn't the same investment in the speech when you're a company that is regulating other people's speech than when you are yourself a speaker. And so we will see often in jawboning cases, it is the company, it is the broadcast station, it is ABC, it is the newspaper, or it is Facebook that is being targeted by the government pressure, but it's the individual speakers or posters or writers whose speech is getting taken down. And often, if there is going to be any First Amendment challenge, it's not going to be the company, it's going to be the individual speakers, because it's their speech that is actually suppressed. They have the most skin in the game, but they're often the ones who are least positioned to know anything about what is happening behind closed doors. And so there is this problem of proxy censorship. There is this tripartite relationship that makes jawboning a very tricky problem to use the courts to solve. And certainly with the current discovery rules and standing rules and motion to dismiss a standard, the Twombly and Iqbal standard, it can be very hard to get into court. So there is, just to note that there is uniformity, there are similar features in all of these contexts, but it is true that perhaps the relationship between the social media platforms and the individual user is even more attenuated than a newspaper and its columnists, or a newspaper and letter to the editor, or a billboard company and the billboard makers. And so that means on the one hand, it's going to be less skin in the game for the company, so maybe more receptive to government pressure, and also harder for the user to know what the hell is going on when their speech is taken down, and so harder for them to bring a lawsuit. On the other hand, the internet is although it is absolutely regulated by all kinds of laws, there is the legal regime that regulates the social media platforms is different than, in particular, the legal regime that regulates the broadcasters. And I think there's a second dimension when thinking about the susceptibility of speech companies or media companies to government pressure, which is the amount of discretion that the government officials possess over those companies, the ability that they possess to wield their official powers to make life really difficult for those companies. And I think we should recognize that the FCC, while I think it has played an enormously important role in the history of American media regulation and in preserving free speech in all kinds of ways through structural regulation and ownership caps and preserving a diverse array of speakers, also wields enormous discretionary power. The public interest standard is a very underspecified power. And so I think, I'm not sure that the social media platforms are more receptive to government jawboning than the broadcast stations, because the broadcast stations always have this sword of Damocles hanging over their head, which is the threat of license revocation. And we saw how incredibly effectively Brendan Carr used that in the Jimmy Kimmel case against ABC, just by suggesting that he might invigorate the public interest standard. It made all those broadcast stations that were affiliated with ABC very nervous. Now, there was, I think that's also a case of how intense political blowback and public pressure can stem even the most sort of aggressive attempt at jawboning, at least partly. But I think it's an indication that we should not assume just because the social media jawboning has gotten the most attention for all kinds of reasons, some of them political, that the social media platforms are the most receptive or the weakest link in our chain. I think actually what's so interesting about a lot of the cases that came before the courts involving social media jawboning tactics is that the platforms were often quite resistant, not totally resistant. And there was a lot of negotiation, I'm sure, that occurred behind closed doors about what could and couldn't flow on the platform. So I'm not saying that they're the heroes of the story, but I'm not convinced that they are the most easily pushed around. A small billboard company in a town that receives a letter from the local mayor that says, hey, we're going to change your zoning regulations, or we're going to impose greater taxes on you unless you take down this ugly billboard, may be much, much more receptive than the social media platforms. And so again, just a reminder, we don't know what we don't know. So we know a lot about pressure on social media platforms, but that doesn't mean that similar kinds of pressure are not being wielded even more effectively against many other kinds of actors all the time.
Yeah, as somebody who was personally jawboned quite a bit during the 10 years that I was a lawyer at Google, I can attest that platforms at the time, at least, did a lot of pushing back on government pressure. And for people who are interested in the sort of personal narratives of some people from platforms who are out in public life now, there was a Knight First Amendment Center series of blog posts on jawboning a couple of years ago, which possibly all three of us wrote posts for. But Yoel Roth in particular, and also Katie Harbeth and Matt Parlow, wrote about what they specifically experienced, which I think is sort of a nice illustration. I want to flag for a little later Genevieve's reference to users not necessarily knowing about the role that the state is having in suppressing their speech and not necessarily have a means of getting into court, because this, of course, was at issue in the Murthy ruling last year. And we will talk about Murthy in a couple of minutes. But before we move on to that, I want to sort of stay in 2025 for a moment and just ask, maybe I'll start with Genevieve, whether or how you would expand what you just described as a way of thinking about universities being pressured and the rights of their students, law firms being pressured and the rights of their clients. Like, are there other kind of big picture current government pressures on the institutions of speech that you think are relevant here?
Yeah, I mean, I think this is a really important time to be having this conversation because the ironies of history. After in part running on a campaign against the censorship of the social media platforms and claiming the mantle of free speech, President Trump and the Trump administration has taken up with vigor and joy the powerful tactic of jawboning. And jawboning seems to be one of the most common techniques of power that the administration is currently using, and its targets are expansive. So I would characterize much of what the administration is doing with regard to universities, the threat of taking away federal funds, the threat of taking away student visas, the threat of destroying them by whatever means are available, in order to get them to agree to a whole host of demands, the most recent being the Compact for Excellence in Higher Education, which requires profound transformations to how universities do business. That is can be characterized, I think, as a species of jawboning. If we think of jawboning as using, as Daphne suggested, non-legislative means, threats that we're going to do something bad to you unless you change how you speak or how you regulate other people's speech, and in particular, in this case, suppress a lot of speech, then that's a very powerful attempt at jawboning. The effort against the law firms in order to continue to receive government contracts, access to government property, government benefits in general, the Trump administration has made clear that law firms have to comply with their views on who are the appropriate clients that they can retain and who are the appropriate lawyers. And I'll just remind everyone, all the audience, that the litigation is First Amendment protected activity. The threats against the media companies, the threat, implicit or explicit, of taking away the broadcast licenses of ABC, but also the threat of not giving merger approval. I think all of this is a species of jawboning. And so we are seeing jawboning hit the big time. The Trump administration, interestingly enough, and I think in part because of the strength of the modern First Amendment, and also the weakness of Congress and the complete paralysis of our political system, is not using the familiar tools of speech suppression, laws and statutes and regulations to enforce ideological conformity or suppress speech. It's using jawboning. It's using threats of doing bad things through unofficial means ordinarily. And so, as I've written about, I think we're in an era of jawboning, and it is incredibly important to understand what the First Amendment has to say about it, but also the limits of what courts can do to protect against it.
So it's interesting, Genevieve, the examples you just gave about universities, but the thrust of a lot of the state pressure there is to silence speech. It's stop teaching certain classes, stop letting students, engage in certain speech. Same with law firms, stop representing certain clients, stop bringing certain claims. Same with the FCC and Jimmy Kimmel. That was sort of a speech suppressive state pressure. But if we think about platforms and Meta, for example, or the Texas and Florida laws, if we think of those as sort of part of the same political constellation, there a lot of the pressure was to leave up speech. Platforms were taking things down in a way that 5 justices of the court later said was an exercise of the platform's editorial rights. But what the state pressure was pushing toward was leaving more speech up. And in January of this year, we saw Meta proudly announcing that it was no longer going to take down quite as much speech harassing immigrants or being cruel to people based on gender difference. So, that was a platform leaving up more speech in response to state pressure and maybe forfeiting its own editorial rights, but it's a net gain in maybe gain in quantity of speech. Derek, I'm interested in your thoughts on whether that's different. If the state comes along and says take more down versus leave more up, are those different from a constitutional perspective?
My view is that they are not different, at least from a sort of First Amendment perspective, is that in some senses it's a little bit of must carry, right, which works in some contexts and not in others. I do think that the optics are strangely different. And just, to give you a parochial example, the University of Florida, we've had some trouble hiring a new president, and we have an interim president who has been defended as a protector of free speech because he wrote, or at least signed on to, amicus briefs in favor of the Texas and Florida laws that were challenged by net choice. And the idea is, well, how could you possibly be anti-free speech if all you want is, a sort of greater marketplace of ideas? I find that a little bit mind-blowing because, being forced to carry the government's rhetoric is, I think, one of the sort of prima facie kind of First Amendment violations that we all worry about. I will say that in some senses, I've been wondering, to go back to our initial query, as to whether we need a different term than jawboning. When I think about it, I think about jawboning as one particular type of pressure, right? Which is pressure on, and it could be, I think you're absolutely right, it could be universities, it could be law firms, et cetera, at the sort of margin of a government actor's power. But there are all sorts of ways of influencing speech or censoring speech that I think are arguably within government power, right? So we confer enormous control over spending on speech. That makes sense. If the government wants to sponsor textbooks on democracy, they don't have to include material about authoritarianism or communism. That's fine. But those particular levers, when in the hands of a sort of clever administration or the clever head of an executive branch agency, are remarkably potent and are not ones where I think the doctrine gives us a lot of grip in terms of checking them. And so I think that's one of the really hard things. And I tend to think about this kind of category more broadly as soft censorship, right? There's so many ways to engage in soft censorship, and I think of jawboning as a species of it. And it makes me wonder if what we need is some sort of doctrinal evolution of either jawboning or soft censorship and the pieces that you talked about, right? So, what happens if you're using legitimate government authority for something that is plainly and openly a, a sort of end that it's not designed for? What happens, what should we do about the standing rules that Genevieve referenced? And so, in some ways, it might be that this is a grand opportunity for us to sort of rethink how free speech doctrine is configured. I guess that with that said, I am slightly nervous about our collective capacity to do that in this particular political moment.
Genevieve, do you have thoughts on that?
Well, this has been a wonderful conversation, but we haven't really talked that much about the doctrine. So I thought I would just take Derek's opening to just talk a little bit about what I see as the strengths and the weaknesses of First Amendment doctrine when it comes to combating this problem. So on the one hand, I agree that jawboning is not the only way to characterize the forms of pressure that the Trump administration is imposing on universities and law firms and media companies. Jawboning is not the only it's not the only set of cases either. Like, I think that the wonderful strength of the First Amendment is that in the wake of the McCarthy period and in the wake of the second Red Scare, the Warren Court and then later courts developed a whole range of what I call anti-leveraging doctrines to try and prevent the government from using its legitimate powers to do things that we might think of as illegitimate. And this includes the Bantam Books v. Sullivan, which articulates for the first time the kind of First Amendment anti-jawboning rule, but also the doctrine of unconstitutional conditions, the doctrine of retaliation, and a greater concern with sort of viewpoint discrimination more generally. So there's a whole, you can think of the pressure on the universities. On the one hand, it's jawboning. On the other hand, is retaliation. On the third hand, is unconstitutional conditions. I'm not sure it matters. The doctrinal tests are a little bit different, but they're rowing in the same direction. And so, in fact, there is quite a considerable amount of law on the books for those who are being targeted by this kind of government pressure that's really, really good. And so I do think that the First Amendment after the McCarthy period has developed a quite sophisticated view of what, when the government uses legitimate power illegitimately, or when it uses the promise of power illegitimately, all of these sort of right on the edges, taking advantage of all of the both soft and hard forms of coercive authority that the government has by means of the control of the wealth and power of the regulatory state. There's actually a lot of doctrine on the books. On the other hand, at the same time, and maybe in response to the emergence of unconstitutional conditions doctrine, the court then pivoted a little bit at the Berger and the Rehnquist courts and developed this sort of this robust doctrine of government speech. And there is a lot of questions about, well, when is the government merely speaking and saying, I would like this, and when is it in fact jawboning? I think that particularly when it relates to spending power, the ability of the government to fund speech that is in articulating its point of view can be a problem because that can distort the marketplace of ideas. And so I think there are real questions about how broad do we want government speech doctrine to be. I would love it, Derek, if this is an opportunity to narrow government speech doctrine. I think that'd be amazing. I don't see that appetite, certainly not among the Supreme Court, but maybe to the contrary. But we'll see what this political crisis brings. But on the other hand, okay, so there's all this formal, substantive doctrinal protection, which is great. And I think these rules are fantastic. And I just should mention, I mean, we have to mention this. It's required by the terms of being a First Amendment scholar. The NRA v. Bullo, one of the best First Amendment decisions to come out in recent years, the court just very recently reaffirmed in a very strong opinion the sort of strong protection that the First Amendment provides against jawboning. So it's not as if these are all old cases and old precedents. That was a unanimous decision last term or the term before in which the court reaffirmed that this is a very strong doctrinal rule. But on the other hand, there are all these procedural problems. There's the missing plaintiff, the fact that the targets of jawboning, often it's not in their interest to come to court because they stand to lose more than they stand to gain, even by a court victory. And that's part because of the failure of First Amendment remedies. You cannot get damages for First Amendment violations committed by federal officials. Congress has, in its wisdom, has not seen fit to authorize that damage remedy. I think that should change. That would be a number one fix, but you can only get injunctive relief. And often, what does the injunctive relief get you, right? If there's a merger on the line. And then also there are these standing and proof problems. And so there's a whole bunch of procedural and remedial problems with using the courts as the mechanism to defend against jawboning that I think we are really seeing the effects of with the unwillingness of institutions to come to court because it's just not worth their while. Even while, I mean, it's incredibly frustrating, even while we have this very strong and important doctrinal precedent that they could use if they chose to go to court or if they could get in the door, but they can't or they don't.
So that is a great sort of overview and pivot to turn to focus a little bit more on the cases from last term, NRA v. Vullo and the Murthy case. I'll sort of ask each of you to talk about a case, but before we get there, Genevieve, I loved your framing about the range of, I think you called them anti-leveraging cases from the 20th century. You mentioned unconstitutional conditions, retaliation, which I think is what one of the concurrences in Vullo said would have been the better framing, the Bantam books. And to that, I would add standing. Like Bantam said that book publishers had standing to challenge a law that regulated booksellers, and overbreadth. Overbreadth allows First Amendment plaintiffs to challenge a law's effect on absent third parties. So there are just a lot of ways to doctrinal tools here that can be leveraged. But since the Vullo and Murthy cases were such a big deal last term, and Murthy in particular is such a focus, I would love to, maybe I'll start with Derek and ask you to talk about Murthy and just like explain what happened there. And then Genevieve, we can switch to you to talk about Vullo, which gives us way more answers than Murthy did.
Murthy was in some ways a great case and in some ways a terrible case. It was brought by a set of plaintiffs who claimed that their speech, in particular on Facebook, had been suppressed at the request or demand of Biden administration officials. And one of the things that made the case so complex was that they named essentially sort of every federal agency as a defendant, including, the CDC and the Surgeon General. And if there's one thing that I feel confident about, it's that the Surgeon General has very little power over speech. He's just, the Surgeon General is just not a threatening figure. And I think that one of the things that became important about this is that it turned into a case about standing. And one of the frustrating bits is that, in contrast to Genevieve's excellent explication of the sort of substance of the doctrine, right? That we have this very rich history of doctrine. Standing is always the get out of jail free card for federal courts who don't wish to address an issue. And so one of the things that also made this hard was that the plaintiffs had engaged in pretty clear forum shopping. They brought the suit in Louisiana in front of one particular judge who was friendly to these claims. And, many plaintiffs do this. The difficulty is that Judge Doughty just basically made up the facts in the case. And that's never great, right? So even the Fifth Circuit, which I think is relatively kind to jawboning claims and to this sort of plaintiff, had to walk back a great deal of what he had inserted as facts. And then the Supreme Court, through Justice Comey Barrett, did the same thing. And so what it did was, instead of dealing with, the sort of merits of this and some of the more difficult First Amendment questions, it essentially disposed of it on standing grounds. The one thing that I think that Murthy raises that is a very difficult question is how we can disentangle decisions made by platforms themselves, or by universities, or by law firms, or by newspapers, take your pick. So in other words, what decisions might they decide to come to on their own versus what decisions might they come to as a result of government pressure? Because it could be that if you decide that, as Meta, that you want to take down posts about, ivermectin is the perfect treatment for COVID, you might be doing that just because of the kind of, scientific consensus that it's not. On the other hand, you might also be doing it because you're getting threats from the Biden White House. And if both of those pressures point in the same direction, it becomes very difficult, I think, to figure out what is jawboning and what is not. And in some senses, I think that's why Vulo is the better case, but also a case that leaves some questions unanswered. I'm not sure, and I think Genevieve might differ a little bit on this. I'm not sure that we emerge even from Vulo with a clear test, right? I'm not sure that we understand how to recognize jawboning when we see it. And with Murthy, although I know it's back at the district court level now, it's, well, we just don't think that any of these particular people, have the right to be in federal court. Vulo is so plainly an instance of, inappropriate government pressure, although at the state level rather than the federal level, that it does tee up much more clearly this question of, what is a violation of the First Amendment and what is not. But I feel like both of these cases together taught us less than I had hoped that they would.
Genevieve, you want to pick that up?
Yeah, I mean, I think Murthy's a really interesting case because I'm not sure we know exactly what it means. When it was handed down, I was very unhappy about the standing analysis and the decision. It's such a complicated case because it was so clearly a culture wars case. It was brought for all kinds of reasons. The facts development was very shoddy. The lower court and the Fifth Circuit opinions were full of holes. And so the whole thing was plagued with problems. And so it's kind of hard out of that to distill takeaways. Because one takeaway is that the courts are relying on facts that may not be real and are acting in a very sort of hand wavy fashion when making rules, and you don't want that. And then it comes up to the Supreme Court, and they clearly don't exactly know what to do with this case, because I think we're very unhappy with the poor fact development in the lower courts. But also maybe don't want to say that there is no constitutional problem here. And so just find a convenient out by dismissing it on standing. And it turns out, I think, as the opinion by Justice Barrett makes clear, that the fact development is a problem, not only for the analysis of the First Amendment questions, but also for showing standing. I mean, I think the plaintiffs didn't even show that their speech had been suppressed necessarily within the time period that they're alleging the government imposed pressure. So there are all kinds of problems. And so one way to read Murthy is that it's just an outlier case. It was a problem child. It had complicated politics, and the court was getting rid of it however it could. And so it'll be very rare to see such a poorly argued case in the future. And so it's easy to distinguish Murthy. On the other hand, some of the analysis suggests, just as Derek pointed out, that there is going to be real problems in cases where you're the speaker, you're not the direct target of the jawboning, as will often be the case. So you have no direct knowledge of what happened or what actually motivated the decision. All you know is that there's a lot of government pressure, and then there are independent political reasons for the platform or the media company or whoever it may be to take down your speech. And in those cases, Murthy suggests potentially, depending on how broadly or narrowly it gets read, because again, the facts there are so bad that you could easily say, oh no, but only in extreme circumstances. But if it's read more broadly, it could be that in those kinds of cases, it's going to be very hard to get into court, even if in reality, it turns out that the government pressure was an important factor. And this is a problem also because, of course, it's often going to be the case that the government is going to be jawboning, and there's also going to be private pressure. The government is also a political actor. It's going to be jawboning in ways that are politically efficacious. So it's going to be acting against a background where it's not. This is often the case that we see in the history of jawboning. There's going to be private actors seeking the suppression of speech, and then government actors. And so you can often say, well, the media company or the university or the social media company, they're responding to the private pressure, not to the government pressure. And that's completely constitutional. It's just when you are acting in response to government pressure that there's a First Amendment problem. And so I don't know what Murthy means, but I do worry about the standing analysis. And I think the standing analysis is completely insensitive to the First Amendment equities at stake here, and to the fact that in most of these cases, the problem is not that we're going to have too many plaintiffs in court, but the problem is that it's going to be really hard to get people in court to vindicate these First Amendment values that the court has said belong to all of us. We all have an interest in a public sphere in which the government doesn't play this overweening, it doesn't have this overweening power. And so I think Murthy is a problematic decision, but I'm hopeful that it can be narrowed, not expanded. Although I'll just end my conversation about my discussion about Murthy on a pessimistic note. I do think it's notable that in the Columbia First Amendment case about the pressure that the Trump administration put on Columbia to change how it operated, and then the settlement that Columbia fashioned with the administration, it was very careful in all of its discussion of their settlement to say, oh, these are things we would have done anyway, or we were doing anyway, clearly attempting to inoculate itself against precisely the kind of arguments that the court said, that the jawboning arguments that it feared were coming and have in fact come in the form of an AUP suit against the Trump administration. And the district court, relying heavily on Murthy, said that means that the plaintiffs don't have standing. If that is how, I think it's a bad decision. The judge clearly had many motivations to want to dismiss the lawsuit, was not sympathetic to the claims. It has been rejected, that broad interpretation of Murthy, by other district courts. So by no means the last word on the subject, but it is a sign of how dangerous Murthy can be if we think that there are real problems with getting people into court in the first place, having a very restrictive standing rule in jawboning cases. On the other hand, the positive note is that I think the rule from Vullo is that the government actors violate the First Amendment whenever they attempt to jawbone. You don't have to show that they actually jawbone. What Vullo, I think...
Vullo, sorry, Genevieve, can you set up what Vullo was and just explain the case? Thank you.
So Vullo is a case that comes out of New York State. It's not a federal case, involving these allegations about the chief regulator of insurance companies and banks, in coordination with the governor at the time, Cuomo, to pressure the insurance companies that provide services to the NRA in the wake of the Parkland school shooting to disassociate themselves with the NRA. And the allegations in the complaint were that if they didn't, Maria Vullo, the regulator, she would go hard on them for all of their regulatory infractions under the complicated, capacious New York insurance law. The claim was not that they weren't regulatory infractions, but that she said, I won't prosecute you for these if you disassociate from the NRA, but I will prosecute you for these if you don't. And so here we see exactly the promise of the exercise of what is, in some sense, legitimate government power. She actually does have the power to go after the companies for these regulatory infractions, being wielded in an unconstitutional manner to suppress or threaten companies into suppressing or disassociating with speech. And the court there says, it rejects the claim that because these are legitimate regulatory powers that she has, that means it's okay. So it has a pretty expansive view, I think, of what counts as jawboning. And it also rejects claims that are required there to prove that this was the only factor in the company's decisions. And the rule that it embraces, and again, unanimous decision, although there is a concurrence, is that if a government official reasonably conveys a threat of adverse government action in order to, with the intent to suppress or get a private actor to suppress or disassociate from another actor because of their speech, that violates the First Amendment. And so it appears to set forth a pretty strong, I've actually argued, a categorical rule against this kind of intentional threatening in order to suppress or intentional coercion by government actors. And so Vullo says, if you have enough information, you don't actually have to prove that the jawboning was causal, that it resulted in the suppression of speech, at least from a First Amendment perspective. But then Murthy says, in order to get to court, you have to. So there's this kind of double bind. Do you have to show causation? Do you not have to show causation? It depends.
Genevieve, I love the point about the intervening volition, or the let me say this differently, the evidentiary question about whether you can trust platforms when they say they did something voluntarily. Because if your theory of the case is that the government has pressured them into taking action, it does not seem reasonable to expect them to show up in court and sort of be truthful about that. So there's an evidentiary angle on the question. And then there's also, I think, a substantive First Amendment angle, which is like, okay, well, what if this platform really just wanted to do whatever the government told them to do? They were passive and they saw a political advantage in doing that. Is it jawboning if the platform wasn't coerced, but in fact perfectly happy to do the state's bidding? And we have doctrinal analysis from the circuit courts before Murthy, including the Fifth Circuit, saying, yeah, that it's unconstitutional for the state to act when a platform is just passive and doing its bidding too. But neither Vullo nor Murthy kind of give us a hook for talking about that they're both very focused on the idea of coercion. So in a couple of minutes, I want to close out by asking you both what you would tell Congress, since there's a hearing about this tomorrow. But before we move on to that, Derek, I do want to give you an opportunity to kind of come back on these doctrinal questions because Genevieve raised so many interesting points.
Thanks. I think that so I agree that Vullo comes closest to establishing, clarity, to the degree there is clarity on this, I think that there are a number of different pieces that are sort of still floating out there. And one of the difficult ones is what constitutes a threat. Because, in Vulo, obviously, these actually were legitimate violations of, New York's insurance code. It turns out that you can't offer to insure people, even in the event that they use a handgun for homicide. And that requires that if we're going to take that seriously, we have to look at intent. And intent is one of the hardest things to sort of parse out in criminal law or anywhere else. And so, to the degree that a threat from the government to take certain action requires an intent on the part of the government actor, it also requires, as you and Genevieve both mentioned, that we undertake some analysis of sort of how robust the platform or the target of it is, because we don't want it to be that the target will have had to take some action other than the one that it wanted to take in order for there to be either standing or a substantive violation, because we don't want to only have, sort of like either weak or strong platforms that have standing, or weak or strong actors that have standing. And so I think that is both something where, I think it's maybe the dissent, I think it might be Justice Alito's dissent in Murphy, that comes the closest to putting forward something that looks like a formulation of a test, right? It's a three-part test. The difficulty, obviously, is that it's a dissent. And so I think that that's something where actually a lot of work needs to get done, which is how do we sort of conceptualize what jawboning is, what are the edges of it, in a way that doesn't have the Goldilocks problem that Genevieve described, right? We neither want too many nor too few plaintiffs, and we need to worry about that in the sense that these regulatory targets, even if we just stick with social media networks for a moment, they have a real incentive not to get in trouble with the people who might regulate them, right? So they are very unlikely to sort of bring challenges. And so that requires, I think, a good deal of kind of careful construction in a way that I don't think either case really took up. The kind of thinking in both cases, or the reasoning in both cases, struck me as kind of relatively fuzzy and as sort of a missed opportunity. Like these are two cases where you have one that probably shouldn't be a jawboning violation, that's Murphy, and one that almost certainly should be, and that's Vulo. But in neither case, in my view, did the justices really come to something that is highly clear as far as a test goes, or even as far as a set of factors go. And what that means is we're going to have to do this all over again.
Oh, go ahead.
Well, just jumping in. I mean, so I think Vulo is pretty clear as far as it goes, that when it comes to explicit threats of enforcing regulatory infractions or prosecuting regulatory infractions you wouldn't otherwise, we now know that the threat of adverse government action, when it's articulated or alleged in a relatively clear way, in order to get the target to suppress speech, that violates the First Amendment. I think we know that after Vulo. I think that's really important to know, because it turns out that the Trump administration is making a lot of very explicit threats of, we're going to do bad things to you unless you stop speaking or stop others from speaking. And so I think Vulo is extremely relevant in the law firm cases, in the university cases, in the media cases, because the administration is being so clear. But I agree with you that Vulo, in part because it had such dramatic facts, does not reach the question that Daphne teed up for us earlier, and that I do think there needs to be more development, which is, what if the threat is implicit? What if there is a repeat relationship between the regulator and the company, which often will be the case, where they know when the government says, wouldn't it be nice? I would love this, or I like children's TV and I hate sex and drugs and TV. And they know that that means, well, if you don't comply with us, bad things are going to happen to you. But no one has to say it, because they're in this intimate relationship of reciprocity where they understand the rules. This is what Judge Bazelon once called a raised eyebrow harassment. You just raise your eyebrow, raised eyebrow jawboning. You raise your eyebrow and the target knows what's occurring. I think under Vulo that would be hard to win on, because there's no explicit threat. And so there is this question about what to do when there is implicit encouragement or coercion or threat, or just a desire on the platforms to please the government and therefore to do whatever it wants. This is a really tricky question, tricky terrain, as for all the reasons Derek just suggested, because of course, on the one hand, if courts go too far in recognizing raised eyebrow jawboning, then virtually anything where the government has any point of view about the matter under consideration could lead to a jawboning case, and we don't want that. But on the other hand, I think there is lots of reasons to think that this is a very effective tool of government speech suppression. So I guess I still have a lot of faith in juries. I think I would open up the standing rules. I would have a very broad test for how you get into court and how you plead a jawboning case. And then the question for the jury would be, well, was it in fact the government pressure on your view of the facts and the circumstances that resulted in the suppression of speech? In part because I think we just need to get so much more information about what is happening behind closed doors. What are the ordinary practices of government pressure and the intimate relationships between government regulators and private media companies? And we don't know this. Murphy was a problematic case for all kinds of reasons, but I am so glad that there was even the limited discovery there was, because we now know a lot more about the relationship between the Biden administration and the social media platforms. And while some of it isn't troubling, I think some of it, from my perspective, is troubling and I think borders on unconstitutional, and we would never have known it. And so this is just one case. In most cases, plaintiffs just get tossed out at the motion to dismiss stage, and they never get to discovery because of these difficult standing evidentiary rules. And the result is that the courts are not being used as an important vehicle for getting us information about this critical relationship between our regulators and our media companies. And I would really appreciate a rule that allowed there to be more information forcing, so we can know what we don't know right now about how these relationships actually play out in practice.
And I'll just tease out from that something we haven't had time to get to, which is like, what is the Goldilocks zone of government speech? Because as Genevieve alluded to, and the Second Circuit and Bulow talked about in more detail, we elect these people based on their policy positions. They ought to be able to go out and talk about that, including if it's a policy position that relates to online speech, because kind of everything relates to online speech these days. So, there's a Goldilocks zone for what the government should be free to do also, particularly in public. So we have 3 minutes left, and I want to know what you would tell Congress in this jawboning hearing that is happening tomorrow. What's most important for them at roughly 1.5 minutes each? Derek, do you want to lead off on that one?
Sure, and I promise to be quick. I would say two things. One is that I would ask, given the current political composition of the Congress, that, I would ask Senator Cruz, what among all of the things that the Biden administration did counted in his view or in the committee's view as jawboning? And given those things, what should be the remedy for that? Because I think that, as always, it's, jawboning is a tremendously attractive technique when you have control over it, and it's a vicious and sort of mean-spirited tactic when the other side has control over it. And so I think if they were to focus on, okay, well, what is it? Was it the contact with the CDC? Was it the contact about Hunter Biden's laptop, et cetera? The ability to kind of tease out with specific examples what counts as jawboning and what doesn't, and what ought to be done about it in a way that sort of flips the political valence, I think is important, because otherwise it's very, very difficult outside of the context of litigation, and sometimes even within the context of litigation, to determine what is jawboning and what is just legitimate objection or government speech. And there's almost no way to do that from behind the veil.
Genevieve?
I guess I would have two things. One, I would say, well, if you're so worried about jawboning, will you authorize damages for violations of the First Amendment by federal officials? I just think we should do that. And if they say they're concerned about it, there is a handy dandy tool at their disposal that they can help alleviate the problem. Because one way to think about what jawboning is doing is it's trying to evade the courts. And so one response to jawboning is to make it more attractive for plaintiffs and easier for plaintiffs to get into the courts, so that we can have courts figuring out this very difficult question that Derek was just talking about, which is, what is the line between government speech and unconstitutional coercion? Legislatures are not going to figure that out. We cannot figure that out on our own. We need good, clear rulings on it. And so we need more people into courts. And then the second thing I would ask is just like, why the focus on social media platforms without thinking about the universities, the law firms, all the targets of jawboning right now, if they are so concerned about this problem, and I think there is good reason to be concerned about the problem with respect to the social media platforms, why no expressions of discomfort about the pervasive reliance on jawboning as a tactic by the Trump administration?
Well, those are both great points, particularly in light of the fact that Senator Cruz has a draft bill that I think is not public yet, but that could potentially be drafted in recognition of both of those issues. And it is sort of wonderfully a topic that for which there is hopefully bipartisan concern, because everyone's been hurt by this, and everyone's benefited by this, perhaps in political circles. Anyhow, on that rare moment of hope about the First Amendment and free expression, I will wrap up this panel and hand this back to our hosts at CDT.
Thank you so much, Daphne and Genevieve and Derek, for that in-depth and informed discussion. I may or may not have cheered out loud when Genevieve suggested damages for violating the First Amendment. You all covered so much interesting ground and highlighted some difficult questions we face. Now we're going to turn to Section 230, often maligned as a get-out-of-jail-free card by its critics. Section 230 serves a number of vital and speech protective functions online. Specifically, it can help covered services withstand jawboning. So as a reminder, we're taking audience questions throughout the session, with the exception, the fireside chat was an exception, so we will be taking audience questions now. If you're connecting through the Zoom webinar, you can use the Q&A function at the bottom of the window. If you're following on the live stream, you can submit questions via email at questions@cdt.org or via X or Blue Sky using hashtag CDT questions, hashtag FOSO2025, and at SendDemTech. To lead our expert panel on Section 230, I will now turn it over to Samir James, CDT's Vice President of Policy. Hi, Samir.
Hi, Kate. Thanks so much for the introduction. So as Kate said, we're going to talk about the role that Section 230 plays in fostering and protecting free speech online. Professor Kossa famously described Section 230 as the 26 words that created the internet. Yet as we approach Section 230's 30th anniversary next year, it is quite a milestone, it remains a subject of significant controversy and misunderstanding, with calls from both Democrats and Republicans for it to be reformed or even repealed. Today, we're fortunate to be joined by a stellar group of panelists to discuss how Section 230 has served as a firewall for free expression and how it benefits internet users. Their bios are available on the website, but let me briefly introduce them. First, Ryan Carroll, who's a senior counsel to U.S. Senator Ron Wyden and previously a senior advisor at the National Telecommunications Information Administration within the Department of Commerce. Rudy Frazier, who's a technologist, community organizer, and co-founder of Black Sky Algorithms, which we'll talk about more during the discussion today. Rudy's also a fellow at the Applied Social Media Lab at Harvard's Berkman Klein Center. We have Ash Kazarian, who's a senior legal fellow at the Future of Free Speech at Vanderbilt, where she works to protect free expression and uphold the First Amendment in the digital age. She has a background both in industry at Meta and in civil society at Tech Freedom and Stand Together. And finally, India McKinney, who's the Director of Federal Affairs at the Electronic Frontier Foundation, where she leads the organization's advocacy before Congress on issues of digital free expression, and previously had served as legislative staffer on Capitol Hill for more than a decade. And as Kate said, my name is Samir Jain. I'm the Vice President of Policy here at CDT, and maybe most pertinently, I represented America Online back in the day in the Zarin case, which was the first decision interpreting Section 230. As Kate said, we'll leave some time at the end for questions from the audience, but feel free to throw them in the mix at any point during the panel, and we'll try to get to as many as possible. So to begin, as the description of the panel says, and Kate mentioned, 230 is sometimes portrayed as a get-out-of-jail-free card for big tech. Ryan, Senator Wyden was one of the authors of Section 230. Is that a fair characterization as to what he was trying to do? What was the purpose of Section 230, and what does it aim to protect?
Sure. Hey, everybody. Let me take the second part of that first, and then I'll come back to the first. So my boss, Senator Wyden, then Rep. Wyden with Chris Cox in the House in about 1995, with the help of some historically important anonymous House Ledge Counsel, wrote Section 230, basically to stand for the proposition that the companies that host user speech and the users that organize other speech on those platforms are not held civilly liable for the other person's speech. Before Section 230, there were a couple of court cases that did find that those companies could be held liable. So perhaps most famously, in the case involving fraudster Jordan Belfort and Stratton Oakmont, posts about that brokerage on Prodigy Services prompted sort of a New York State opinion that said that Prodigy could be held liable for the speech of people calling out Belfort's firm. So to my boss and Chris Cox, that seemed like a really bad idea and really bad for the development of online speech and holding powerful people like Belfort accountable, right, online. This was a really great thing that was happening, and these decisions seem to get it backwards. What incentive would platforms have to allow users to post their content on their websites if they could face an avalanche of litigation for doing so? So it's a simple proposition that's become more complex over time as the technologies that host and organize speech have become more complex. Whether it's a get out of jail free card, it's a loaded question. My contention is it's not. I won't quibble with the fact that it immunizes platforms from lots of claims that are brought against them. But importantly, in 230E1, platforms are still criminally liable. So when a platform, for example, knows of a specific instance of CSAM on its service, it must remove that or risk criminal penalties. Also in the definitions and built into C1, platforms aren't immunized for their own speech when they're not hosting the content of another, right? So courts have taken this lots of different ways. Snapchat was sued for its speedometer app in Lemon v. Snap. That was linked to a fatal car accident. 230 didn't apply. Airbnb and HomeAway were sued for violating local ordinances. 230 didn't apply there. Amazon was sued for selling a defective battery in, I think it's the Bulger case in California. 230 didn't apply there. Meta has been sued for discriminatory practices with regards to its ad delivery service. 230 didn't apply there. I think the discourse around 230 doesn't actually lend itself to recognizing how carefully courts are drawing these lines and where 230 sort of isn't applying.
Great, thanks, Ryan. Ash, let me bring you into the conversation. So, clearly there's some overlap in terms of Section 230 and the First Amendment. We're not going to go deep into the First Amendment in this panel because subsequent panels are, but sort of talk about the ways in which Section 230 serves some of the same interests, but then also what does Section 230 add to the picture? Why is Section 230 important if we already have the First Amendment?
Thank you so much, and thanks for having me. I think one of the main things is that the First Amendment and Section 230 are looking in the same direction, right? Like they have similar goals under them. But I think the biggest difference is that they do it through the different mechanics. The First Amendment protects our speech against the government, and the precedent over that was built over many decades. Section 230 fills the gap of, well, the speech is protected, but when you get dragged into court and you have to go through all the stages of a litigation to prove that the First Amendment is protecting that speech, well, you're out of a lot of money. And it's also different because of the legal system of the United States. It's so much more expensive to do that here. There's some really great research done by many organizations, including Engine, that represents startups' interest in DC. And they did this paper about how much it would cost for a startup to go to court and use the First Amendment, prove that what they're doing is protected by the First Amendment editorial discretion or so on. But they would be out a lot of money, which startups or individuals, users don't have, because Section 230 protects all of us. So I think that's the main thing. Section 230 is this great tool for protecting our free speech rights when you get to court, and it is expensive because otherwise those with deep pockets like Jordan Belfort would just, users were discussing on that forum that he was a scammer. But he was just suing them into oblivion, and that was the wrong incentive. So Chris Cox and Ron Wyden were on the right track, and now, almost 30 years later, we can see that Section 230 is there to protect those who just don't have deep pockets to hire lawyers and go through stages of litigation. I mean, even lawyers, like I had something happen where I know if I go to small claims court, I would win, but I don't want to put someone who went put themselves through law school through that And if I can't ask myself of that, can you imagine asking someone who isn't as familiar with the legal world to do that? So I think that's the big one here.
India, you want to jump in, add anything here?
Yeah, I mean, I think Ash has it exactly right. I mean, one of the things that we talk about a lot is Section 230 protects users. It doesn't protect big companies. So, like, let's talk about Instagram. There are a lot of small businesses that run part of their business on Instagram. So, yes, Section 230 protects Instagram itself. Section 230 also protects the individual person, the individual user that's on there. They can moderate their comments, they can delete things that are not relevant, they can do all of that other stuff. And that is something that Section 230 allows them to do. The other piece that we really want to make sure that people remember is the parts of 230 that work extremely well, so well that we don't notice it, is that Section 230 is the thing that allows companies to moderate spam. We know spam exists. We see it occasionally. We see it when stuff gets through, but companies across the spectrum are pretty good at moderating spam, and they're not held liable if they screw it up. If you get rid of some of these 230 protections, some of that moderation is probably going to go away. And all of a sudden, we're all going to start seeing a lot more things about how I can make $500 this week from sitting on my couch, because there's less of an incentive and more liability if they get it wrong. So there's a lot of things about Section 230 that protect individual users, that make small voices more likely to be heard, easier to be heard, to give them a way to get their message out there, not so much as a protection just for big companies. And also, remember, all big companies started as small companies. Section 230 is relevant at the beginning. You see Meta taking out full page ads in the New York Times to reform Section 230. They are one of the biggest companies in the world now. Of course, they would like to moderate Section 230 to benefit them, and they have an army of lawyers. They will be fine. If they can use the courts to preempt any potential future competitor from being able to get off the ground and scale up to be the size to actually be a competitor to Facebook, why wouldn't they do that? Why wouldn't they be in favor of that? So when you're looking at changing the rules, look at who it benefits to change the rules. Is it a big company who's going to be able to figure out how to still be in business? Or is it a smaller company that could get sued out of existence, as Ash said, just because they don't want to take themselves to court because it's expensive, it's hard, and you don't necessarily want to deal with it? Just go away, as opposed to fighting the good fight. That's not, especially right now, you got to pick your battles. They may not pick this one. One of the things that we say at EFF2 is it's not the Section 230 you don't like, it's the First Amendment. There's a lot of things that people are allowed to say that you don't necessarily like, and there are consequences for that, but one of the consequences is not the government preventing you from saying it or punishing you for saying it.
So Rudy, let's bring you into the conversation. You founded a small company, Black Sky Algorithms. Tell us a little bit about both what Black Sky does and then how Section 230 protects you or is important for you.
Yeah, so with Black Sky, we're a startup that builds infrastructure on the app protocol, which is a decentralized social media protocol. And we make it possible for communities to be launched and hosted on that infrastructure and kind of really control all of these things, control their moderation, control their algorithms, control their governance of their space, while still being connected to a global social media ecosystem. And we've been very involved in the protocol from the very early days. It's a protocol that was designed by Blue Sky. And I think while everyone has spoken really well to the risks to startups and how this would, this being a part of my work is a part of this decentralized social media movement, the changes to these laws could end up reinforcing centralization. It could end up being that the major players like Meta, who can, Mark Zuckerberg was recently doing an interview where he said, talking about AI, where he said they can afford, if they lose a couple $100 billion, that would be unfortunate. And that is very much not how a startup can operate on a very shoestring budget. So they can afford to pay the lawyers and deal with any regulation that comes their way. It will really end up hampering any of the many that people people are launching social media startups all the time, and I think we should want and encourage that. The other piece to this is decentralized social media, which is a whole different framework that these, I think the conversation should consider at the very least, because, for example, at Black Sky, while we have an app, you can go to blacksky.community and then you'll be interacting with the tools that we've built. But you could also be on the Blue Sky app and using the moderation service that we run, where we label content as anti-Black harassment or misogynoir. We also run this background infrastructure that hosts users' data. Either it's like we're the home server for a user, where their data, like we are the source of that data. Really, for anyone who's unfamiliar, Blue Sky and App Protocol kind of works like you can imagine one social media app that is ran by many different companies. So the app that you download is one company, the feed that you scroll is another company, the place that holds your data is another company, and you can choose who your moderators are, and that could be a different company. And so, as far as if I run when we started, we were just a algorithm, a feed on the Black Sky or on the Blue Sky app that surfaced black content and content from Black users of the platform. Does that count as speech? Does that count as like us publishing a feed? Does that count as speech? If we're doing just labeling of content and we're not taking down the content, is that the traditional form of moderation that folks consider? So where do people operating at the protocol level fit into to some of this? These are where there's like lots of gray area. And if folks start becoming liable, if you're like a relay is this transient data source, it's storing all the 40 million users, all their posts, all their likes, everything they say, all the not images, which is a different layer, but everything they say is coming through our pipes and infrastructure, and then we're storing it temporarily as like a cache, and then fanning that out to people who are subscribing to our service. And so, like, if we're just this infrastructure layer for someone, do you have responsibilities around what those users are posting? So if people, I think there's opportunity, there's situations here where there's like innovation could just be really hampered. I think we're doing really interesting stuff in the app protocol ecosystem, but if you can't even run a background service that's different from what people imagine as a platform, then I think people who are running Mastodon instances, for example, like them becoming liable for what their users post, that would be very detrimental to this decentralized social media movement.
Okay, great. Thanks, Rudy. So let me ask the other panelists. We've gotten a question from the audience who essentially the question is you all are extolling the benefits of Section 230, but we know social media is undermining democracy through disinformation, deepfakes, and all. How do you reconcile that, or what do we do about that?
I'll take that one.
Okay.
I'll start. Every new communications platform has come with a similar level of criticism. You go back to the printing press. If you make the printing press widely available to let anybody do anything with it, that undermines the rule of law. If you let people print things and widely distribute things that are fake, that are untrue, that are satire, that are rude, that are lewd, that are whatever, that contributes to the downfall of society. Now, not saying that is not true. It is true. But when you have a free exchange of ideas, when you have a free exchange of all ideas, who gets to decide what the ideas are, good ideas and bad ideas? And that's actually the question. It's not whether or not it's good or bad. It's who decides if it's good or bad. When you're specifically talking about deepfakes, there's a lot of reasons that deepfakes are protected, because it is very difficult to distinguish between what is a problematic deepfake and what is a satirical, what is political commentary, what is First Amendment protected speech. And again, who do you want deciding those things? It's very easy to look at a thing with an individual instance and say, that is bad. Do you want the government to be making those decisions at scale? Do you want the current government? Do you want the previous government? Do you want the next government? Who do you want deciding what is okay speech on the internet? That is the relevant question to be asking here. Because we can look at it and say, this is bad, this is hurting people, this is doing whatever. And that may be true. And also, it is helping people. The same tools that may be leading to the destruction of society as we know it are also the same tools that are organizing protests to help protect society as we know it. And who gets to decide if it's good or bad? And that's what the First Amendment protects. That's what 230 protects. And that is the thing that we actually need to be thinking about. Who is the decider?
Ash, did you want to jump in?
I would absolutely agree with everything India said, but I would also say that today talking, the big theme is jawboning. And we've seen everyone across the political spectrum be very mad at Section 230 for one thing or another. Some people have been mad at it for disinformation or misinformation that exists online. And my question is, are they mad about Section 230 or just the speech itself, right? Section 230 doesn't create mis or disinformation. Section 230 gives an opportunity for platforms, users, organizations, let's say Wikipedia, right? That's owned by the Wikimedia Foundation. They use Section 230 to protect themselves from lawsuits. Because there's some people right now, especially that think that what they're hosting is biased and misinformation and so on. So my question just becomes, is it more about like the speech itself? And again, as India said, well, do you want whoever is in power who you wouldn't like to have the power to decide what that is? We're already seeing everyone everyone in Congress drag, heads of small, medium-sized, and big-sized tech companies and say, well, if you don't do this or that, we're going to repeal Section 230 or amend Section 230. So the fact that it's becoming a bargaining chip, I think should say a lot, that I don't think it's the Section 230 that's the problem here. And there's a lot of ways to address mis and disinformation, including, by the way, the centralized internet. But because there isn't a silver bullet, and we as humans often want to gravitate towards a silver bullet, that's what happens.
So let me follow up, Ash, in terms of, we've talked about how Section 230 is designed to protect against liability for third-party content, what users and other third parties are putting up. But some of the pushback, certainly recently on 230, has been, well, but what about platforms that are engaged in recommendation? They have algorithms that recommend certain content, that amplify certain content. It may be, harmful content. It may be the disinformation that we were talking about. That's the platforms themselves making those decisions. It's not third parties. So why should 230 protect those choices about what to recommend, what to amplify?
I'm going to try not to be long-winded, but I wrote a whole paper about this. So if anyone wants to read it, it's called I Built This Algo Brick by Brick, which is something you say to each other and under posts online, amplifying the fact that they finally have engaged with enough posts to see something they weren't expecting that was speaking to them. So long story short, it's not even Section 230. We now have Supreme Court decisions in Moody that say that platforms have editorial discretion over the third-party speech, and like when they moderate, it's their editorial discretion to do so. Now they use algorithms to do so because even if all the platforms had employed everyone on the planet, it wouldn't be enough to deal with the scale that we have, the scale of speech that we have. The way I think of algorithms and the way they recommend content is if you still go to libraries, or maybe at one point you have gone to a library or a bookstore, that feels more common these days. Books are categorized by different, sometimes random categories that the bookstore decides or the library decides, and sometimes, by region and eras and things like that. And that's what algorithms do. They help categorize that speech so you can actually sift through and find what you need. And depending on platforms, they use different signals to figure out what to show you and what not to show you. I mean, you can go on Instagram and just decide that you want everything in chronological order, and that's what you're going to see, and only see things from people you follow. I think platforms have been experimenting a lot with what they want to show. And we as users can decide if that's something, if this algorithm and this way of seeing content is better than the other. And then when it comes to Section 230, we for years thought that Section 230 protected algorithmic recommendations, and there wasn't really a debate around it. A few years ago, the Supreme Court took up two cases, the Gonzalez v. Google and Tomno v. Twitter, and then didn't really decide on this question. They kind of punted, which was confusing to a lot of us. And then now we have a circuit split. In the Third Circuit, we got a decision in the case Anderson v. TikTok, where the court had said that because of Moody, algorithms are platforms' own speech and hence they're liable. It didn't make sense legally. Like legally, it's just not coherent, if I'm being honest. But now we have a circuit split again. So your question, while I am of 100% confidence that Section 230 protects algorithmic recommendations, it's now pretty urgent that we have a circuit split in the country. Maybe the Supreme Court sooner or later is going to take up a decision to rule on the question now. But yeah, that's kind of it.
And Rudy, this is sort of where decentralization can really be a practical solution, because if you've got decentralized moderation, then users can make choices among, what algorithms or recommendations they want to follow or whose recommendations they want to follow.
Yeah, absolutely. I think instead of, introducing again all this like additional regulatory overhead on smaller platforms, one option could be that social media platforms adopt these open protocols that offer users more choice. So instead of, if the concern is that there are these big, powerful platforms that are, because I totally agree, X is, for example, their algorithm is constantly surfacing up all the worst content on the internet for folks. Instead, just give users more choice. Require the platforms to adopt these protocols that give the user the choice. So on at Protocol, for example, there are I think over 100,000 or 50 to 100,000 different custom feeds that someone can choose. And so the platform like Blue Sky has their defaults, but users can remove Blue Sky's defaults, completely ignore their feeds and create their own algorithms as well if they and people are building tools to allow people to control their own algorithm. And so I think providing users with the tools and choices that allow them to have a more healthier online experience. Also with the decentralized moderation tools, there are folks who can build, you can build, you don't have to wait for like Twitter to build community notes. You could build an experiment to do community notes. You can do, more other experiments in moderation where maybe you have like a crowdsourced moderation of some kind that you build, or you use, you leverage AI models to try to like identify misinformation. Or there's folks that I know who are working out of the MIT Media Lab to do research on like when social media posts are taken out of context, and that could be just a labeler on Blue Sky. And so I think, decentralization, like not just that concept of decentralize the platform, but the actual tools that allow people to run small parts of the network that give users more agency in the long run is a good solution for this.
If I can also add to that, if we could, talking about giving users more choice, let's also talk about antitrust and competition. Like if the goal here, like you want to get rid of Section 230 because what you really want to do is sue the tech companies, then we need a comprehensive consumer-focused privacy law, federal privacy law. And if what you really want is to get consumers more choice, we need a lot stronger antitrust protections. We need an antitrust bill. Ryan, if y'all could just get on that, that'd be super great. So if what you really want is more user choice, and if what you really want is for consumers to be able to sue the tech companies, Section 230 is not the way to go because we still have the First Amendment. If you actually want to hold people accountable, give them real choices and give them privacy and an actual way to enforce it.
So in a minute, I want to shift the conversation to where we're going in the future with AI. But before we do that, I do want to talk about one other sort of active area where there's questions about the application of 230. And Ryan alluded to this earlier, and that's the relationship between Section 230 and product liability. So in the Snapchat case, the decision that Ryan mentioned before was a case in which two boys were tragically killed in a car accident due to high speeding. And the allegation there was that it was Snapchat sort of speed filters in combination with some of the things it was doing in terms of offering rewards through the online space that caused that car accident to take place. And the claim, and the Ninth Circuit eventually agreed, was that Section 230 didn't apply to that because that was more about product design and wasn't about third-party speech, and that 230 didn't protect against that. Now, people have sort of tried to take that theory and expand it further to say that, even the algorithms, bad algorithms are part of, bad product design, and so Section 230 doesn't apply. Be interested in anyone on the panel, maybe Ash or India, if you want to weigh in on sort of how you think Section 230 should or shouldn't apply in the product liability context.
Well, so I don't want to talk. So EFF is involved in a lot of active litigation around 230. So I don't want to get out over ahead of my skis before my litigators. But one of the ways, I will just say briefly, that we think about product liability in 230 is what is actually the product that we're talking about. If the product is the speed filter, which is a thing that Snapchat itself created with a direct relationship to the user, the product is something that Snapchat created and controlled. If the product that you're objecting to is actually another third party's speech, then 230 would apply. If the product is speech, it's an entirely different category of something that the platform doesn't control. But of course, the lawyer answer is, it depends.
I think we've seen a lot around the country, on especially state level legislators, attempt or even pass legislation that is trying to kind of say, oh, this is more about product liability, or this is about regulating conduct, not speech. We just actually have seen in California the governor veto or not sign SB 771 that was saying that algorithmic recommendations for that were not, it was tying to some to California civil rights acts and saying that basically if it was recommending speech that was going to be in violation of it, then Section 230 wouldn't apply, which also on one level, your state legislature, you can't regulate things that are preempted on federal level, but I don't know if California is aware of that. But even if we let go of the preemption question, it was also clear that what was happening was they were trying to regulate speech, right? They were regulating the speech that, let's say, might have been hateful or terrible. That brings me back to what India was saying and EFF says is sounds like you have a problem with the First Amendment because the First Amendment is what protects this kind of speech. And Governor Newsom and his office, I think, saw that. And so this bill didn't pass, but we're seeing a lot of, in other states, things similar to that attempt to pass. And there are a few active litigations and challenges around design choices that so far, I believe, are landing on this First Amendment protected activity side. But sooner or later, it's going to make its way to the Supreme Court, just I think mathematically, because there's so much active litigation.
Okay,
Yeah.
so
Sorry. Yeah, just to piggyback on that, right? I would really commend to folks some of the decisions that try to grapple with this. I think even in the most favorable decision to sort of the plaintiff side, in the Los Angeles Superior Court case that I think is now combined in the MDL in the Northern District of California, that judge was still very clear about saying that cases that are primarily about sort of content repackaged as products liability cases do not pass muster. I'd also say just there are so many sort of nested questions in the product liability space. In I think it's the November 2023 motion to dismiss order, and where that parses out sort of the 230 questions, the First Amendment questions, and sort of the core sort of tort questions on how this all applies here is really tangled. So it's tough. I know that's a dodge to not sort of take a position sort of one way or another. But I think folks sort of outside the niche sort of 230 platform government space would be really interested perhaps even to see what Judge Nelson wrote in in the Ninth Circuit this winter about sort of what's protected First Amendment activity, which can include displaying likes and reshares, like that kind of platform activity is First Amendment protected, according to Judge Nelson.
So speaking of Tangled, let's shift to, we're moving into a world of AI now, as Alex said in her opening remarks. AI is increasingly mediating our content online, whether you're talking about chatbots, social media feeds of AI-created videos. And so the questions arise about sort of how does 230 translate here? In 2023, we had a Georgia radio host who filed a defamation claim against OpenAI, alleging that ChatGPT had falsely stated he was accused of embezzling funds in a legal case. And it turned out ChatGPT had made it up. There was no such legal case. But, we've now got questions about how does Section 230 apply in this new world? And so, Ryan, let me begin with you, because I know your boss has expressed some views on this. As currently written, at least, does Section 230 apply to these services?
Yeah, so I don't think it does. 230 is in large part about immunizing platforms where they're sued for acting as the publisher or speaker of the content of another speaker. I think it's that last bit of 230C1 that puts generative AI sort of outside the traditional coverage of 230. So ChatGPT, Claude, Sora are all creating new or unique content. That is like the image or text or video that they're putting in front of a user arranged in that specific way did not exist sort of prior to that interaction. While some sort of user input or speech is upstream of that generation, I think the level of transformation and development of the user's idea makes it very unlikely that it would receive sort of 230 protection, and makes it a lot different than sort of AI recommender systems, which are sort of the AI that we were talking about before. I also think it's very telling that in the district court in Florida, that character AI hasn't raised sort of 230 as a defense to any of the things that they're being sued for. I think if they thought that there was a viable path there to raising a 230 defense, they would have raised it.
Just as background for audience, the character AI case that Ryan mentions in Florida was another tragic set of circumstances in which the allegations from the parents are that a teen who was interacting with the AI service character AI was led to commit suicide as a result of those interactions. And so the parents have sued character AI as a result. And that litigation is ongoing. As Ryan said, they haven't up to now raised a Section 230 defense. They have raised First Amendment defenses, which the court essentially didn't really decide for the moment, but that remains an ongoing case. Let me ask other panelists, do you agree with Ryan that section, as currently written, that Section 230 doesn't apply to the chatbot kind of context, or is it, in your view, more complicated or different? Ash?
Every time a lawyer says it depends, an angel loses his wings. So I do think it depends. I think there are cases when it does apply. So based, for example, on the question the user asks, if I just say to a chatbot, give me a paragraph from these 5 websites on this question, and all the chatbot does is copy paste that information, I think there is an argument to be made that it's just showing you, right? It's not repurposing the information. It's not creating new speech. It's just taking paragraphs and showing it to you. I think there is an argument to be made that in that case, it would be protected by Section 230, but it is very case by case basis. So that's one. I mean, it's hard to say yes when Chris Cox and Ron Wyden are saying no. At the same time, it will be interesting to see how courts interpret it. We're still in such early phases of figuring out where this is. And if you hear anyone who calls themselves an AI expert and tells you very confidently where they think this liability is going to fall, I wouldn't trust that person. So that's where I think we are. And I do think that we would benefit from a policy or legal standard that would apply across the country, just because it would help the innovation and would also help the startup sector that is maybe not the few big companies right now that are already kind of gearing up to be the ones who are comfortable with some of the regulatory capture. But that's just me.
I would also caution folks from, using AI as too much of a blanket term. There's a lot of stuff that's been around for a really long time. Algorithmic decision making has been around for a long time. Large language models have been around for a long time. Chatbots have been around for a long time. And so a lot of them have undergone the sexy AI rebranding, but it's not actually different from a lot of stuff that we've seen previously. So I'm not a lawyer, so I can just say it depends, and the angels get to keep their wings. So it really does. What are you talking about? All AI is not the same. Generative AI is entirely different than some of these other things that we're talking about. And so there's an entirely, having one universal standard is a little bit more complicated when what you're talking about is so vast and so broad.
And even within generative AI, you have the chatbots, but then you have things like Google AI mode or Google, the AI search summaries. So people now, when they engage in search, they're not necessarily looking for the list of links, which are pretty clearly third-party content, but then they're getting the AI summaries at the front, which are drawn from that third-party content, and maybe in some cases just quote that third-party content. But there are a lot of different fact patterns. Although that raises the interesting question, I think, when we were talking about 230 earlier, I think Ash sort of made the point that one of the reasons 230 is so important is because it eliminates a lot of the litigation, because you don't have to go into court and do a lot of factual development. You can sort of just assert 230 and that's the end. This may be a case in which actually you have to, if you're going to use 230, you actually have to litigate the facts. And so it may undermine, in that sense, the benefits of 230 to the extent it applies to AI. But let me ask you.
So Mark, if I could just, Ryan said this at the beginning, Section 230 is not blanket immunity. It is actually pretty limited immunity. And one of the things that it does not protect against is things that the companies actually do, choices that they actually make. And so they are not exempt, companies are not exempt from federal criminal law. They are not exempt from a whole host of things. And so figuring out exactly where those things lie, it is not blanket immunity. So it is complicated. And so as I think you said, this actually may be something that the courts need to figure out, because it is not blanket. Which is people talk about the blanket immunity of 230, and it's not, it is limited.
What do you all think in terms of, leaving aside the question of whether 230 as currently written applies, should there, Ash, you alluded to the need for a federal standard, but should there be immunity or some form of immunity for chatbots and other AI services, or should we just go back to the tort system along, obviously supplemented by the First Amendment? Or do we need a Section 230 for chatbots or for generative AI? Ryan?
Yeah. So a few things. So it might turn out that, like, as a matter of policy, like, we decide that things like Perplexity or Google AI mode or mere sort of like summary services that look closer to what courts have said is like 230 protected before. I think there are some cases against Google where a Google summary defamed somebody, and they said it was it wasn't Google's sort of slight modifications, adding like a few words, periods, like font spacing, did not amount to like the roommate's material contribution test, right? So it might turn out that we want Perplexity, these companies, to have that kind of immunity. I think that's not what 230 is for, right? And so I'd rather wait until we have our sort of generative AI, like Cubby, Stratton moment to decide, once a court has decided sort of either way, and see what comes, and sort of do this like we did sort of Section 230 back in the 90s, because no court has sort of said either way on this, especially before legislating. I also worry that construing 230 to sort of cover generative AI, getting sort of further afield from like the Perplexity examples, right? You might end up with like a judge-made rule that really broadens the coverage of 230 to anything where like a user input sort of upstream of any kind of output or some sort of user interest becomes covered, and creates lots of sort of 230 coverage then beyond sort of what I think any sober appreciator of internet policy might actually want. So I'm wary of that as well.
I would invite everyone who's watching to go to the Future of Free Speech website and look at our very recent study we published, where we go through all the major chatbots and kind of try and see if they would answer some controversial topics and talk about them or not, and if maybe some of them redirect or change the topic or just like don't answer, and all of these specifics. And after you read it, let me know if you think there should be liability or no liability or limited liability on chatbots for doing this, right? Because the trade-offs, as Ryan said, we need our own Cubby, Stratton Acmont moment of what are the trade-offs? What is the balance here? Do we want more speech, less speech? As we are moving into AI, and we're using AI very generously and across era, if we get this wrong, it's going to apply to so much speech and it's going to chill so much speech. And we've seen this in some ways, like we've seen some states try and regulate AI deepfakes. And by that, they're just, I think, regulating deepfakes. We're just attaching the word AI to like make it somehow different or go around the First Amendment. And so I think we also need to fight the urges to do that.
And I mean, we're talking about AI as, or the chatbots as though they're separate from users, but I think as the earlier discussion indicated, in many cases, chatbots or similar kinds of services might be ways for users to express themselves, right? I mean, if you're thinking of pictures or art and, you're not a great artist, but you can work with a chatbot to create something. And, what rules of liability do we want around something like that? And when the output is really an amalgamation of the AI system and the users, it may not be strictly 230 protected because the AI is playing some role, making a material contribution, but it nonetheless is in some ways part of the user's expression. And how do you want to protect that, and how do you protect that? I think is a difficult question. So we alluded at the beginning to the fact that everyone wants to modify 230 or repeal 230. There's probably something close to unanimity in Congress. Yes, we should change 230, but there's really no consensus on what we should do exactly. And there are different goals that Republicans and Democrats often have when they talk about modifying 230. Ryan, let's begin with you since you're in Congress, and tell us sort of what is the current discussion around modifying 230? What are some of the prominent ideas? We'll get to the likelihood of any of that actually happening, but let's sort of talk about what's the space of potential ideas around how 230 should be modified.
Sure. So there are a lot of bills introduced or promised, right, that would amend sort of 230 explicitly. And I think importantly, let's discuss many more that might sort of overwrite parts of it implicitly. And I think the Take It Down Act that passed sort of earlier this year might overwrite parts of 230, and that's going to be a tangle for courts to deal with. And that moved quite quickly. But we can talk about that when we talk about the likelihood of any of this happen.
Right.
I think there's, yep.
No, just spend 1 minute. What is the Take It Down Act, and why did it potentially implicitly repeal 230 or modify?
Sure. It requires sort of notice and takedown of non-consensual intimate imagery, right? 230 should immunize platforms for sort of hosting sort of other speech, things that aren't illegal imagery, right? I think 230 would traditionally offer protection from being asked to sort of take down that content. Now with the Take It Down Act in place, courts are going to have to reconcile sort of what's in the act and what's left of sort of 230. Since it's a later in time law, that might overwrite sort of places where 230 has traditionally offered protection. Hopefully that makes sense. Sorry. Yep. Sorry, what did you say? I missed that.
With other proposals that are there.
Right. Yeah, so I think a major theme of the 230 bills that would amend 230, right, are about protecting children online often, online safety sort of generally. So some bills aim to limit 230's application to civil claims related to the promotion of CSAM. Others create new civil liability for like the reckless promotion of CSAM on their services. CSAM is child sexual abuse materials. Others limit 230's application to new civil claims that would be related to platforms monitoring anything that looks like a drug transaction. And then others that deal with sort of design elements that we were talking about previously might impliedly repeal or overwrite parts of 230 where they talk about platforms have to design to moderate out certain content, right? That has a direct interaction with how 230 is applied. I think that's sort of the major theme for lots of the reform proposals. There's also sort of other bills about codifying 230's non-application to generative AI or going after election misinformation, just to name a few. So there's lots of ideas out there.
Yeah, you follow a lot of what Congress is doing in this space. Other ideas or proposals that you're paying attention to?
I think what I want to highlight for those who are maybe haven't been with us through the decades of these fights, because these are a little bit kind of cyclical, is that the other time when Section 230 was amended, which was Sesta Fosta, what it had created was a lot of unintended consequences that have put more people in danger. And Sesta Fosta was this carve out for Section 230 that the goal was to protect victims of online sex trafficking, right? Great important goal, but it's been used less than 10 times since then by prosecutors. And instead, what has happened is a lot of websites, because they don't want to deal with the liability or even be open to it and being sued and then go to court and have to prove that Sesta Fosta here wouldn't be applying to them, they have shut down some parts of the internet that have helped sex workers and people who are in other communities that kind of would overlap with this type of speech from being able to keep each other safe. And there's a lot of research done and work done on this, but basically the policy consequences were terrible. This hasn't been used to help the victims. It was used to get a lot of political points, and then everyone moved on, and the world is left worse than it was beforehand. So that's my, I guess, cautionary tale here.
Okay. I'll remind the audience we're approaching the end, so if you have questions, feel free to get them in. We'll leave a few minutes at the end. So just use the Q&A tab in the Zoom if you're on the Zoom to do that. But India, do you want to weigh in on the federal legislation side? And maybe also one thing you could maybe talk about is the proposals around sunsetting 230. There are various proposals around the idea of sunsetting 230 after a period of time.
Yeah. Well, so the first thing I want to say is when Ash is talking about how Sesta Fosta didn't work as intended, that's not just us saying that. The GAO actually had a report where they looked at Sesta Fosta 5 years later and found that not only did it not work, it actually hurt some of the people that it was intended to help. Again, not us saying that, that's the GAO saying that. I have a link of that open on my computer. I can share it with the world if you would like. The other thing is a lot of the proposals that we're seeing, some of the things that Ryan was talking about, they don't actually mention Section 230 in the legislation at all. It's like if you don't say it, it doesn't count. But what a lot of these bills are looking to do is, Section 230 doesn't protect, or it doesn't hold platforms accountable for third-party speech unless one of the participants in the third-party conversation in speech is a minor. Minors don't get First Amendment rights. Minors don't get 230 protections. That's a lot of the things that that's the type of things that we're starting to see come forward, because we need to, children are so important that we need to amend their First Amendment protections, which we obviously disagree with. Teenagers have First Amendment rights as well. But Samar, to your question, we've seen Congress is just big mad at Section 230 for a whole lot of reasons, some of them based in fact, some of them not necessarily. And so there's at least one proposal on the table that's like, we're going to sunset 230. Like, if you can't come to the table and help us amend Section 230, we're just going to sunset the whole thing 5 years, and then where are you going to be? And it's like, okay, so first of all, the big players are perfectly willing to amend Section 230 because it helps them to get rid of their competition. You don't want them at the table writing the rules for how they engage online. That is not who you want deciding those things. Second of all, getting rid of a protection that largely benefits users, small businesses, small companies, and otherwise marginalized people is really not what Congress should be focusing on at the moment. Again, if you want to sue big tech, pass a consumer-focused privacy law with a private right of action. If you want to give consumers more choices in the marketplace, pass some antitrust laws, help the FTC and the FCC, hold them accountable. Those are the things that you could be working on, but those are correctly very, very, very hard. It feels easier to just completely erase this thing that has provided massive protections for all of us for the last 30 years, and in our view, is not broken. We've heard a lot of people in this conversation talk about some of the current, there's a split in the circuit courts. The Supreme Court is going to need to weigh in. There are times when platforms are being held accountable because they have been actively engaging with their users. It's not blanket immunity. Ron Wyden was very smart when he wrote the bill back in the 90s. It's balanced and it works the way when courts get involved and do it, it is actually balanced protection. Congress did a very good job at the beginning balancing the protection of what should be protected and what should not be. And platforms are still liable when they screw up. They're still liable if they break federal criminal law. Sesta Fosta, to go back to Ash's example, a lot of the genesis for Sesta Fosta was something that happened, but the perpetrators of the lawsuit, the founders of the lawsuit, were criminally indicted before Sesta Fosta passed. You did not need Sesta Fosta in order to hold this website and these very not nice people accountable for the bad things that they did. They went to jail, I believe, before Sesta Fosta passed. And so the system is actually working the way it's supposed to, even though it doesn't necessarily let you sue Facebook. If you want to sue Facebook, pass a privacy law.
Ryan, I'm not going to ask you to predict whether a privacy law is going to pass, but let me ask you, let me circle back to, are any of these proposals, do they have any chance for success, like the sunset proposal or any of the others? What are your thoughts and, you know, over the next year or two, understanding that Congress isn't doing much of anything at all right now? Yeah, I mean, it's not even session.
Yeah, right. You know, it's hard for me to have a good prediction model. Like I said, I wouldn't have guessed sort of a year ago that the Take It Down Act would be law now. So that sort of surprised me. I'd say there's a lot of concerted sort of and well-organized activity around kids' online safety issues. And there's a lot of sort of staffer time spent thinking about that. So if any of these is going to move with an interaction with 230, it'd probably be by that vector.
Right, and some of those bills, as you were saying, don't mention 230 out loud, but nonetheless would have, or at least intention with it, like the Kids Online Safety Act.
Right.
Okay, great. We have 1 or 2 minutes left and no further questions from the audience. So any last thoughts from our panel before we close things out and I turn it back to Kate? Yeah, Rudy?
I want to share just like maybe like an anecdotal story of like some things that have happened over the last few weeks on App Protocol on the Blue Sky side, which was, you know, there was the heinous murder of Charlie Kirk, and there was a letter sent from Clay Higgins to a bunch of different social media CEOs, including Jay Graber from Blue Sky, and kind of urging folks to take down content that was in there. I think there was like glorifying the murder of Charlie Kirk, and ultimately what that was kind of a domino effect that ended up leading to Blue Sky taking very aggressive moderation against any reference to Charlie Kirk, and a lot of over aggressive moderation policies, and then taking a bunch of content down, which led to a lot of users migrating away from Blue Sky to be hosted by on Black Sky servers. And because of the decentralized aspect of the network, folks, even if they were banned from Blue Sky, their data would still stay up and thus kind of providing a way for folks to, even in this event of these moderation policies, the content still remained. But in the end, it ended up leading to us having to stand up even more infrastructure on the Black Sky side and spend like $7,000 to kind of clone the entire Blue Sky network just to provide those users with the same experience that they were expecting to be able to have all their followers and all their metrics and everything. And so just as an example of where I think government putting pressure on social media companies to moderate any which way can have all these downstream effects on both the end users and the smaller platforms in the ecosystem, like you mentioned.
Yeah, no, that's a great example. And it also sort of ties us back to the very first panel that we had, how 230, if it works well, can protect against that kind of government jawboning because the platform shouldn't have liability. Although even in this case, it sounds like they did take action to try to respond to that jawboning. But yeah, and it also shows some of the complications with, even when we talk about decentralization, that's a complicated concept in terms of how to actually carry it out in practicality. Well, great. Thank you so much to our panelists for that really insightful discussion. And I think it sort of showed why Section 230 is so important and also raises questions about, as we move toward an AI-dominated social media and information space, a lot of open questions as to what the legal regime is going to be over there. But with that, Kate, let me turn it back over to you with thanks again to our panelists.
Thanks so much, Samir, Rudy, Ryan, Ash, and India. What a great discussion. Really helpful. Thank you all so much. Next panel. So generative AI is still an emerging technology. It's also becoming increasingly ubiquitous, used for everything from search to customer service to companionship to therapy. Many governments are examining the safety of these tools, but it's also important to examine what it might mean for governments to influence their output. As a reminder, we're taking audience questions throughout the session. If you're connecting through Zoom webinar, you can use the Q&A function at the bottom of the window. If you're following on the live stream, you can submit questions via email at questions@cdt.org or via X or Blue Sky using hashtag CDT questions, hashtag FOSO 2025, and @SendDemTech. All right, leading our expert panel discussion on this rapidly developing topic is Becca Branham, CDT's Free Expression Project Deputy Director. Becca, over to you.
Thanks, Kate, and thanks all of you for joining us today. We increasingly live in an AI-mediated world. Our cars steer themselves, our feeds curate what we read, and our chatbots help us read and reason. But these same systems can also reflect bias, leak private data, or silence certain perspectives. In Washington, the debate around governing AI has started to split along familiar lines. As in the social media era, concerns about safety and accountability are butting up against accusations of censorship and bias, again asking us to answer complex questions about how to govern speech mediated by technology. This panel will dig into the constitutional and practical stakes of that divide. What happens when government starts defining what counts as objective or safe for AI systems? What should we think about free expression rights when algorithms, rather than human editors, are deciding what to say? And what should we be doing about all of that when policymakers are watching closely? For that, I'm delighted to be joined by an extraordinary panel. First, we have Min Ong of the Global Network Initiative. As GNI's Accountability and Innovation Manager, Min is responsible for leading the evolution of the GNI framework, as well as facilitating the GNI's unique company assessment process. Before joining GNI, Min led the sustainability team of a major telecom company, developed a community-led human rights impact assessment methodology for a digital rights NGO, and led 2 microfinance institutions in Myanmar. I'm also delighted to be joined by my colleague, Miranda Bogan, who is founding director of the Center for Democracy and Technology's AI Governance Lab. As part of our governance lab, Miranda works to develop and promote adoption of robust, technically informed solutions for the effective regulation and governance of AI systems. Miranda has led advocacy and applied work around AI accountability across both industry and civil society. Before CDT, she guided strategy and implementation of responsible AI practices at Meta. Miranda also previously worked as a senior policy analyst at Upturn, where she conducted foundational research at the intersection of machine learning and civil rights, and served as co-chair of the Fairness, Transparency, and Accountability Working Group at the Partnership on AI. Next, we're joined by Neil Chilson of the Abundance Institute. Neil is a lawyer, computer scientist, and author of the book Getting Out of Control: Emergent Leadership in a Complex World. As head of AI policy at the Abundance Institute, Neil works to create a policy and cultural environment where emerging technologies like AI can develop and thrive in order to perpetually expand widespread human prosperity. Prior to joining the Abundance Institute, Neil was Senior Research Fellow at the Center for Growth and Opportunity. Next, we have someone who, among the FOSO crowd, probably needs no introduction, but I'll give him one anyways, who is Eugene Volokh of the Hoover Institution. Professor Volokh is the Thomas M. Siebel Senior Fellow at Hoover. For 30 years, he's been a professor at the University of California, Los Angeles School of Law, where he taught First Amendment, copyright, criminal, tort law, and firearms regulation policy. Professor Volokh also clerked for Justice Sandra Day O'Connor of the US Supreme Court and Judge Alex Kaczynski. And last but most certainly not least, our friend from the ACLU, Cody Vensky. Cody is the Senior Policy Counsel at the ACLU's National Political Advocacy Department, working on issues in surveillance, privacy, and technology. Cody focuses on comprehensive consumer privacy legislation, safe and non-discriminatory AI, children's privacy, and civic uses of data. And most importantly, prior to joining to the ACLU, Cody worked with us here at CDT as senior counsel as part of our equity and civic tech team. So with that esteemed panel, I'm excited to dive in, and maybe Min, you could start us off. I know that the Global Network Initiative has been examining government interventions into AI worldwide. What can you tell us about the ways that governments are currently or contemplating shaping the way that AI is used, whether for better or for worse?
Yeah, thanks, Becca. Just checking, can you hear me okay?
Yes.
Okay, great. Right, well, it's a real pleasure to be a part of this panel and the Freedom of Speech Online, of course. As you rightly noted last week, so we launched a policy brief on examining the human rights implications of government interventions in AI. The report is indeed a product of several months of work with GNI's multi-stakeholder AI working group, which includes a range of academic, company, investors, and society members, including CDT. And I'll share a link in the chat after I stop speaking if anyone's interested in reading. So within this policy brief, we examined the many, many ways that governments are seeking to influence AI. And we developed a taxonomy of 5 broad categories of government interventions across 3 segments of the AI value chain. I won't go over it in detail. I'll share a link in the chat for those that are interested. So I'll get to the crux of at least what some might find interesting on this brief. So the brief essentially analyzes, after going over several examples across that taxonomy, both within the US and outside, the brief analyzes the impacts on freedom of expression, privacy, and non-discrimination at a high level, before concluding with recommendations for governments, companies, and for civil society. So just as a snippet of what the analysis contains, an example, it contains, the analysis reveals both opportunities to advance human rights risks, as well as risks of human rights violations from government interventions in AI. If I could just give a few brief examples, we have identified government actions that can help protect rights, which include, for example, requiring or encouraging human rights assessments, developing thoughtful risk-tiered taxonomies of use cases with corresponding levels of risk management, privacy laws, investments to enhance public access, as well as rights-respecting procurement guidelines. We also see, on the other hand, approaches by government that may cause or permit negative rights impacts. So things like mandating overbroad censorship, imposing requirements for ideological alignment. So examples of that include, obviously, the Woke AI Act, and also as well as requirements for ideological alignment in China and Russia, using AI for discriminatory surveillance, overly restrictive export controls, as well as the absence of rights-protecting laws and regulations. Overall, and I'll stop after this with a little snippet, the brief essentially recommends the use of international human rights law to ground government interventions in AI, as well as responses to them, which will hopefully facilitate the protection of rights and also may help build public trust. I'll leave it at that for the time being. Thank you.
That's great, Min. Thanks so much for starting us off with that. Maybe we could pick up on one thread that you mentioned in your overview, which is the Woke AI executive order that was issued earlier this year. As we know, governments have all kinds of levers at their disposal to influence industries. And one lever at the disposal of the US government are things called executive orders. The Trump administration issued an executive order seeking to prohibit the procurement of what they called woke AI by federal agencies, simultaneously demanding that that government procured LLMs both be objective and ideologically neutral, while also demanding that they refrain from outputs consistent with certain viewpoints that, as we understand it, they disagree with. So I'm curious for the whole panel, what do we make of this woke AI executive order? And what it might mean both for government use of AI, but also what it could potentially mean for the private use cases as well.
Maybe I could jump in here first. It's great to be on this panel. I think the Woke AI executive order was part of fulfilling the AI action plan's requirements. And there's a line in the AI action plan that talks about the need to have models be unbiased and anti-woke. And the framing in the executive order, I think, gave a lot of people heartburn, including me. It sounded very much like the executive order was going to lever government procurement, maybe to mandate some sort of content regime or anti-censorship regime across all models for anybody who provided, services to the government. And so it was a bit of a relief that the actual executive order, despite the highly inflammatory sort of preface language that's in there that talks a lot about all the different political concerns that the administration has with how AI might manipulate content. The actual operative language of the executive order really first does just focus on models that are procured by the government, which is a bit of a relief. It's not all models that a company that provides services to the government might have. But then second, it has these conditions for what these models have to be. But part of the way that you can fulfill those conditions is just by, explaining exactly how any of the sort of intentional manipulations you might be making to the outputs of the model. And to me, that sort of requirement of disclosure and a way to sort of comply with this makes it much more practical for companies to do. And so while directionally it might be a little bit concerning, although we should have like a pretty open conversation about whether or not we want the government procuring models that might have political biases or not, or what is the sort of obligation under the First Amendment for that. The fact that you can comply with this through sort of transparency, to me, made it at least a much more practical executive order than it might have been otherwise. And so that's kind of my high-level takeaways from the executive order.
Yeah, I want to echo some of what Neil said. There certainly are things the government could do with regard to AI that would be quite clearly unconstitutional, in my view. So if the government were to say, whether the president or Congress, AI companies cannot output certain views, or must output certain views, or even have to be ideologically unbiased in outputting certain views in general, that would be unconstitutional, just as requiring book publishers to do the same would be unconstitutional. On the other hand, if the government says, when we procure, manuals for use of various tools, or when we procure books for that might be used as reference works by the military or by CIA or even just by ordinary government officials, we want to make sure that there are books that are good in our view, which is to say possibly neutral or possibly even consistent with our ideology. Surely the government must be free to do that. Likewise, imagine you were to discover that some AI, whenever it's prompted on some sort of military or international relations matter, always outputs something that is pro-China, or maybe anti-China, or for that matter, pro-pacifist and anti-military. The government could say, well, all right, we happen to have a military, and we appreciate pacifist arguments. They're not the perspective that we would like people who are using this tool on our behalf to be absorbing from this AI. Surely the government must have a great deal of latitude in saying we will procure certain kinds of things and not other things. Now, to be sure, that might have indirect consequences. There may be that AI companies will say, well, we don't want to have several different models, although I think a lot of the AI companies are willing to have different models. But we don't want to have two different models. If there is a model that is the one that the federal government wants, we'll invest all of our effort into providing that. Yeah, that might indirectly affect what the AI companies do. But again, I think the government has to be able to have to say we want things. We want inputs to our processes. We want tools, because ultimately it is just a tool for our employees that will help accomplish our goals rather than help undermine our goals. Now, of course, there's also as a technical matter what exactly it means for an AI to be neutral and non-partisan and not manipulate responses in favor of ideological dogmas would be pretty hard to figure out, at least in certain situations. Among other things, we want AIs to provide accurate results. And while in some areas what's accurate and what's not is not terribly ideological, in other areas, judgments about what the accurate view about gender identity is or accurate view about international relations is that is not ideologically influenced may itself be a hotly controversial question. So I also appreciate that the ultimate order does, for example, say the guidance shall account for technical limitations in complying with this order. That seems to be some acknowledgement that you can't just sort of have a rule of ideological neutrality and expect it to be followable in some meaningful, legally binding way. So I think a lot of the devil will be in the details. You could certainly imagine procurement guidance that is either too micromanagey or that actually seeks a material that is ideologically biased in particular ways the administration likes that might be counterproductive in certain respects. But I do think that there is a core problem, potential problem that the order seeks to deal with, that I think the government legitimately has to have room to deal with, which is to say the problem that for various decision support software, that software might be influenced by ideological judgments that the government does not share and does not want to see influencing government policy.
Yeah, I think Professor Volek is spot on with his observation about the sort of squishiness around this idea of ideological neutrality. There's sort of a larger epistemological question of what exactly that is. And I have difficulty thinking too about how that squares with the current functioning of large language models and neural networks, which is that, of course, explainability is a very difficult thing to pursue in that space. And those of us who are working on AI and civil rights, where explainability is such a key component for accountability, have run into that over and over again, is that sometimes developers aren't able to tell you how it is they got from an input to a particular output. And we're seeing that as well in the areas of safeguards, where OpenAI, for example, released a report today or yesterday on how ChatGPT is handling suicidal ideation. And they report in 91% of use cases, the safeguards are compliant with their overall goals. But it means in 9% of the cases, they aren't seeing the model track its preferred outcomes. And the same thing arises here. Even with the squishiness of ideological neutrality, we are going to run into problems in ensuring that the large language models, structured as they are, adhere to whatever safeguards that the developers and deployers try to build in compliance with this guidance that we'll ultimately see from OMB.
I'll just add to that, kind of taking a step back. What are large language models and how do they work? Like, what is the training that might lead to them behaving in a certain way? Because each of a number of different steps could contribute to why a model might, tend to respond to prompts in certain ways. And some of them are maybe more visible than others. So first, there's just the raw pre-training itself, which is typically using almost all the information on the internet and any other information that companies can get their hands on, which, that information represents some array of worldviews. Some filtering might happen to remove low quality sources of information, how mindfully, that low qualityness is defined as, there's a whole variety of different ways that could be defined, but typically, like, is it gibberish, or is it, websites that are entirely spam, things like that. Not typically, quite nuanced questions of like what content should or shouldn't be included. Then there's a phase of, tuning models. So giving the models reinforcement, having humans kind of look at different outputs and grade them, or rank preferences of, is this model output better than that model? Sometimes that preferencing happens just, it's sort of like, which one do you prefer? And at other times it's like, how does this output comport with a set of kind of guidelines or something like that? So there can be a variation in how kind of conscious shaping of model behavior happens at that point. Certainly it can get, when a company is trying to shape their model to behave in a certain way, that's a phase where they can kind of say, let's provide examples of what responses are preferred and what are not. But in other cases, it's very much like, is this chatty? Like, is the output logical, right? So you can't necessarily just say that whole phase is like very conscientious. Then there are going to be like quite concrete safeguards, right? Filters, things like that. That's more akin to content moderation that we're going to be familiar with from social media contexts or other online contexts, which relates to very clear policies and prohibitions and things like that. And then finally, there are things that are very obvious interventions in how a system behaves, which is in their system prompt, which is natural language instructions for how a prompt should behave in all cases. And that's often saying like, always respond, in a thoughtful and friendly manner, and be curious, and whatever personality a company is trying to impose. Sometimes rules. So in some system prompts of Grok, for example, there were several mentions of never respond to users about like privacy preferences, which it seemed to me related to their pre-existing consent decree with the FTC around privacy practices, but that was coming up in their system prompt. And one could also imagine putting kind of instructions about how to respond to certain topics in that system prompt. It wouldn't be the most elegant method that I think technologists would think of, but it is a place to intervene. So all of the what happens at all of those phases is quite different, and how you would know what's happening at all of those phases and whether something had added or reduced the affinity for a model to behave in a certain way can happen differently at all those different layers.
That's super helpful, Miranda. I'd love to pick up on sort of that layering, because I think the woke AI executive order is a pretty blunt instrument to get at speech, and sort of what type of speech is at speech tools, and what those speech tools look like when procured by the government. But I know that I suspect, and I know you've been thinking a lot about other less obvious ways that the government might be able to influence the way that LLMs operate, whether they're procured by the government or not. And so I'm wondering if you could chat a little bit about those less obvious measures and what we should be on the lookout for as government gets more involved in the ways that AI systems operate.
Absolutely. One I've been tracking for a while is it really gets at that question of how do we know what's happening within a model? And to Cody's point, it could be really difficult to know why something's happening. It is possible to figure out what is happening, and the way that is done is through what's called evaluations, or evals, or sometimes benchmarks. Both of those are sometimes used interchangeably, but it's basically these are data sets of examples of good, bad, maybe on a Likert scale rating of, how good or how bad is something on some topic area. And so at first we were seeing things for evaluations around model safety, things like cybersecurity, whether models were having the propensity to provide, instructions to people looking to conduct some kind of malicious activity. But the concept of evaluations, has broadened quite a bit. And the way that the government would effectuate the executive order to know if a model that they had procured was perhaps kind of falling on one side or the other of, their preferred definition of ideological neutrality would likely be, in addition, through like baseline transparency of, did you do a very obvious thing like change your system prompt, would be testing the model on one of these evaluations and potentially circulating that evaluation elsewhere, say to AI safety institutes, or, just more broadly in the research ecosystem. And it can be difficult to track exactly what those evaluations are measuring and whether honestly they're measuring anything at all, because in many opportunities it's quite difficult to measure these systems because they're non-deterministic. They answer differently every single time. It's hard to develop a measurement instrument that measures a construct that you might want to measure. Nevertheless, these evaluations across all sorts of topics have proliferated. This is how the industry understands what it is that it's building. And so, if evaluations on topics, whether it's explicitly ideological neutrality or something more broad, such as safety, or any of the subtopics that one might contemplate being related to, ideology or neutrality, if there is influence in the development of those test data sets, it can actually have quite a widespread effect on the field and could end up impacting not only the models that are explicitly procured, but really any models, especially if companies, it's not difficult for them to develop versions of models that would be for government procurement. They might need to also engage in some additional requirements around cybersecurity, things like that. They're already doing those types of tweaks. You could fine-tune a model that was specifically to try to align with the needs for procurement. It wouldn't necessarily affect an underlying foundation model that was in a consumer product or something like that. But if a company was worried that a government worker or really anyone engaging with a consumer version of their product would come across an answer to a question that might be obviously at odds with what the government was hoping to see in the models they procured, that becomes sort of a PR issue. It ends up being an indirect way that the government might end up putting pressure on companies, not only for their procured version of their model, but for their models in general. It'd be easy to rhetorically claim that the behavior of their public model would be indicative of what their procured model would be, even if that's absolutely not the case. But it would be difficult for a non-expert to kind of know for sure. And so that would I could easily see that becoming a rhetorical tool that ends up being used. So you could see those evaluations and the definitions that end up being implemented for government versions to at least be considered in other versions of consumer products, whether those end up being dispositive or the ones that are implemented. It would depend on the appetite of the company to kind of take on that potential risk of just like an example that really didn't play well with a government that they might be trying to get a lot of investment from or get support in, their preferred export policy or infrastructure policy or whatever else. So lots of both technical and political indirect ways that this could affect the shape of the underlying models and the systems built on them.
That's really helpful. And I love that we've been able to sort of dive through some of the different technical layers here about where jawboning might happen through the lens of the woke AI executive order. But I do want to take a step back to the title of our panel, really on jawboning and AI. When the Tech Policy Committee talks about jawboning in the First Amendment, we typically have social media in mind about government interventions to either suppress certain ideas or others. And certainly Republicans in the House and Senate, for example, have long taken issue with some of the Biden administration's interactions with social media platforms and the effect of those interventions on users' online speech. And of course, we know that the Trump administration has engaged in its own fair share of pressure on private entities and individuals for exercising their First Amendment rights. But applying that idea to AI is actually something of a novel idea. And it assumes that there is, in fact, speech that can be influenced appropriately or otherwise through government intervention. But that is an assumption that's not shared by everyone yet. And so I'm hoping we can dive into that a little bit. So when we think about an AI system, let's just think about chatbots for the moment, about the design of those systems, their development, their deployment, their use by a consumer, and then the eventual distribution of their outputs. Where, if anywhere along that continuum, is speech actually happening, or speech that's protected by the First Amendment?
Sure. If I could speak to that, something I've been studying for at least a couple of years now. And let me begin with a hypothetical. Imagine that the government were to say, you can't AI chatbots cannot output any material that is racist, or that is anti-police, or that is anti-Israel, or that is pro-Israel, let's say. And they said, look, chatbots are not human. They don't have rights. We're not violating anyone's rights because we're only restricting what is output by chatbots. think our reaction would be, that can't be right. The government can't impose at least viewpoint-based restrictions like this, because it's aimed at trying to kind of distort public discussion, or at least influence in a coercive way public discussion. And if that intuition is right, then that must be that the First Amendment is somewhere in play. Now, maybe you might argue that there should be less First Amendment protection or different kinds of First Amendment protection, but I think you'd have to acknowledge that there needs to be some First Amendment protection. I would say it should be pretty much full protection, subject to some exceptions we'll get to in a moment, but that kind of hypothetical helps show that there needs to be some First Amendment role for the First Amendment to play. And I think the reason we would have this reaction is because we're not really concerned about the rights of the chatbot, obviously. We might be concerned about the rights of the company. That's possible, although sometimes the company would say, we're not trying to make it output racist material or even anti-police or whatever else. What we are concerned about is the rights of users. The rights of users in what capacity? Rights of users as listeners is the First Amendment term, although maybe readers for text is what we think about. Imagine somebody were to ban the works, I don't know, of Nietzsche or of Hitler or of Stalin, let's say, and say, well, they're dead. You can't violate their rights. They're dead. Plus, they were foreigners in the first place. Not clear whether they have rights. We could say, well, that's unconstitutional because it violates the rights of domestic live publishers of those people. But I think what it mostly does is it violates our rights as readers to be able to draw on the stock of human knowledge and belief, even bad belief, even perhaps inaccurate knowledge. Relatedly, of course, the purpose of chatbots is often to have an interactive conversation with users. So users would have rights not just as readers, but users would have rights as information gatherers and as writers. They may be engaging in a conversation, but because they're trying to get information for an article that they want to write. In fact, they may want to get a first draft of the article that they want to write. As we see with some unfortunate examples that have been in the news, there will be lawyers who want to get the final draft of the brief that they will file. Not a good idea, but still part of their exercise of their speech. Likewise, they may want to have a kind of an emotionally significant conversation. Maybe we think it's a foolish idea to do that, but because it's based on the fiction that the chatbot is real. But, we have emotional interactions with fictional characters all the time. It's a strange thing. We cry when someone dies in a book, even though they never lived, right? So when you're talking with a chatbot and having a conversation, the chatbot output is in part guided by your input. So you are the speaker there as well as the listener. So for all these reasons, I think First Amendment protection ought to apply to chatbot output maybe for the sake of the AI companies, not for the sake of the AI itself, but certainly for the sake of the users. This having been said, the fact that there's First Amendment protection doesn't preclude the possibility of First Amendment exceptions. There have been 6 cases filed so far in the US, for example, with regard to alleged libel by AI. One has been dismissed, another is in arbitration, another was dropped, but at least some of them are potentially quite viable. Just as First Amendment protection doesn't preclude defamation liability for a reporter, let's say, for a human being, so it shouldn't preclude defamation liability for an AI company under the right circumstances. I'll be happy to talk about them later. Likewise, it's an interesting question whether there ought to be some restrictions on certain kinds of interactions with AI in order to shield minors from potentially harmful material. Supreme Court has generally recognized quite broad, although not fully broad, rights for minors. But there's always the question of whether, alongside some other rights, what about Second Amendment rights, right? Whatever you may think about the Second Amendment, it's pretty clear that minors don't have full constitutional rights, say, to keep and bear arms. Maybe with regard to certain kinds of AI chatbots that we think are dangerous enough in certain ways, minors should likewise be shielded from them. So there are interesting questions. But I think the first thing we have to conclude is, and I think courts will conclude, notwithstanding one recent court decision, district court, that I think went the wrong direction on this. First thing we have to conclude is there is First Amendment protection for interactions with AI for the benefit of the users. That's the First Amendment rights of the users that are at stake. And then we have to ask, what kinds of limitations might be permissible under existing First Amendment case law, and maybe if that case law needs to be adapted in some measure.
And I'll just jump in on that because I think it's also important to remember that chatbots are often not just chatbots. Increasingly, they are interfaces to search engines, which on one hand might, involve a whole broader array of information that people have the right to access and how it's displayed. On the other hand, chatbots are being envisioned to and increasingly adding kind of capabilities to take some kind of action on users' behalf, whether that's like a financial transaction or, searching for products or going so far as engaging in kind of housing, employment, credit, like all these areas where we might want, some more rules to apply, because just because an AI is intermediating, that doesn't mean, I hope, civil rights laws don't apply, to the extent that civil rights laws are being enforced, which is an evolving conversation. But the bottom line of my contribution here is I think, we're not just talking about the four corners of a box that kind of gathered a lot of information and is producing it raw. There's all these other layers of intervention companies are making. So those are perhaps editorial choices in different ways. And there are all these connections that these tools are making with external sources of information, and either just showing that information or manipulating it in some way, in a non not a bad way, but just like maneuvering it and maybe taking actions. And there probably is a line somewhere. I think, Becca, you and I have talked about this. It's not clear exactly where that line is yet. And so how will expectations like this play out when that line is truly fuzzy? We're not just talking about content, but at the same time, there's a lot of content involved.
Well, maybe we can put Cody on the spot for that dividing line between sort of the speech that's at issue here, and when understanding how LLMs work and how they might be applied, where speech might turn into conduct, such that the government might have an easier time regulating. I have the civil rights space in mind, but please, we've chatted about this too, so I'm not entirely putting you on the spot, but would love your thoughts. And of course, Min and Neil, feel free to chime in, and I'd love to hear more after this. Would love to sort of talk about the human rights perspective of it all.
Yeah. And of course, drawing a line between unprotected relatable conduct and protected speech is a very easy prospect under the First Amendment. But I think one of the things that's always sort of bedeviled First Amendment analysis in the area of software, going back, as long as we've had software, is the fact that it is a human speech-like activity, and courts appropriately have recognized that source code, recognized by readable by coders, intelligible by coders, is protected speech. But there's, of course, a line where that code becomes instructions that are executed by a machine, and at that point it begins to resemble something more akin to conduct. And of course, as I think Miranda put it in her comments at the top, what is an LLM? What is artificial intelligence? And in many instances, it's doing more than producing an email, a poem, something that we would ordinarily regard as speech, but is actively engaging in decision making that we have readily identified as something more akin to conduct that can be regulated under the First Amendment. So we've made an allusion a couple of times so far to civil rights laws, for example, where large language models, which we're focusing on because those are the topic du jour underneath the woke AI EO, might be engaged in evaluating resumes, evaluating candidates for promotion, for hiring, and making other decisions where we have traditionally applied civil rights law. And there is some limited First Amendment jurisprudence recognizing, yes, although speech might be literally involved in executing that conduct about deciding who to hire, who to admit to a school, it doesn't raise significant First Amendment issues. Now, Professor Volek has written excellent papers on that line around that exception to the First Amendment, often called speech integral to criminal conduct. So he probably has comments here, but if not, I will refer you to his great paper. But traditionally, even where LLMs and others, humans, producing speech that are integral to those decisions, the government can still nonetheless regulate in a way that protects civil rights and achieves other governmental aims.
Can I just build off of that for a second, very quickly? Back to the topic of jawboning, one of the interesting things here is because these models can blend, depending on how they're being used, they can blend, conduct with what we would call more traditional speech. There is a opportunity, a risk here that in sort of enforcing or in the penumbra of enforcement around these conduct restrictions, that there's opportunities for government to really jawbone quite effectively on the speech side, and because the same companies are involved. And so I think there's a risk of that in this particular area.
And I'd love to zoom out just a little bit, Min, I'd love to tag you in here if I can. I think one of the questions that folks have, particularly, there's certainly the public's imagination has been captured by AI, and there's quite a bit of both concern about its capabilities and a desire to rein it in, which begs the question, why are we talking about these free expression implications in the first place? And so I'm wondering if we can situate this, both these interventions, speech-based and otherwise, in more of a human rights framing, and what it could mean, and what risks jawboning and inappropriate government intervention might mean for people's access to information online. Min, do you want to take a swing at this one?
Yeah, very briefly. I mean, obviously, as GNI, we do work on the basis of international human rights law. So a lot of the examples that, while we do obviously get involved in US-related issues as well, we do also get very highly involved in international issues. So perhaps I can provide some examples from an international perspective to see that might be somewhat informative. However, in areas where, in other countries where jawboning has taken place, perhaps the examples are not particularly, well, there's some encouraging examples, shall we say, and maybe some less encouraging examples. So maybe the more encouraging examples are those, I guess, again, this is kind of a borderline between coercion, encouragement, and jawboning. I don't know how you want to say, how you want to frame this, but we have seen situations where, for example, in the UK, where companies allow the government's AI monitoring body to monitor new models before they're released. So that's perhaps an example where there isn't clear legislation for that to happen. But in any case, the previous UK government was able to get the agreement of AI companies to provide their models beforehand. We also have seen, for example, examples of, again, this is quite linked to the US as well, how informal government pressure might impact company behavior. So, for example, looking at the trade kind of discussion, shall we say, between the EU and the US. So the trade-related threats to the EU related to the implementation of the Digital Services Act, while not explicitly focus on AI yet, it may impact the compliance of US-based companies operating in these jurisdictions simply because the government has their back in a way. I think one I'd like to point out, and this isn't exactly jawboning per se, but this is, I guess, very discrete ways where governments can exert influence on company actions, right? So, for example, we've seen in some regulations, the use of third-party audits to evaluate model outputs for safety, right? So, obviously that's happening in California with SB 53, and New York State, for example, requires third-party assessments of hiring algorithms. But if we then look kind of into more, shall we say, concerning examples around the world, you see that, for example, China is requiring self-assessments of models to be filed with the Cyberspace Administration of China before deployment. They don't require third-party accreditation yet, but the risk here is that this, I guess, governments are able to exert influence on companies' actions through these third-party evaluations while providing some level of plausible deniability in a way. In other words, influencing the auditors, right? So that's, those are kind of concerns that at least we have seen over the course of our research in the policy brief, and I do encourage others to read to find out more.
Great. And I want to pick up on something that Professor Volokh mentioned, which was the recent court case, or at least preliminary ruling out of a case from Florida. It was it's a case involving character AI and the tragic passing of a child who interacted with a chatbot and subsequently passed from suicide. The court in that case, my reading of the ruling was that they've more or less punted on some of the First Amendment questions there, but I think it has had outsized influence on the conversation about speech and AI in the United States. And so I'm wondering, Professor Volokh, at least for my mind, gave a very compelling answer about why we should care about the First Amendment in these contexts, but the judge, at least in that case, wasn't yet convinced that the First Amendment questions should be considered. And so I'm wondering if folks are able to speak a little bit to that ruling and maybe what are the best arguments against the position that First Amendment issues should be considered, or some of the limitations of how First Amendment should be considered in the product liability arena.
I think, one issue we're seeing quite a bit of, and I don't know if this is for or against or whatever, but something to think about is, again, there's the substance of the way that these tools are interacting, and then there are the mechanisms of that interaction. For example, chatbots are trained to be chatty. They're trained to ask follow-up questions, even so much that when I was reading a chat transcript that had been exported, and somehow in the export, it was clear that when the chatbot produced an image, there was a hidden instruction that said, do not follow up, end the turn right now, like don't follow up, which suggests at 3 times it said don't follow up, which suggests that the developers of these systems found that when a user asked for an image and it produced an image, they got annoyed when there was a follow-up question. And so because the model had been maybe so tuned to ask follow-ups all the time or produce a follow-up that they had to exert a lot of influence over the model to have it not do that. So there's some propensity of models to be chatty and engaging, and that's maybe not the substance of the conversation, but more about the design of the product, which is this interactive experience. And so there are a lot of other things like that of, how might a product kind of provide resources if someone is in distress? What are the privacy implications if someone is in distress? What would it mean for there to be liability for these types of things? What other implications would that have for how these products are designed? And then ultimately what controls are put on their outputs or the data they collect to take actions that are expected of them in these situations. So it's certainly much more than just did this interaction have this direct effect on this person's kind of well-being, which is very, I think, in many cases, very tragic. And I think OpenAI just released some numbers on how frequently they're kind of observing patterns in this spirit, which is quite concerning. But it's it's intermixed in all sorts of other decisions that are going into just the behavior, so to speak, of the way in which these tools are trained to engage and not so much the substance. And so how will we think about that? Similar to the action taking question of some of these things are just more of, is it a short response or a long response? Does it have question marks and wow and exclamation points, or is it very dry? Those are expressive choices. All these models are given, trained with personalities in a way. That's how developers think about that. But that also has an impact on the shape of a product. And so how will we kind of untangle these different considerations?
I'd love to hear from Professor Volokh on this, but can I just add one thing that maybe you can respond to on it as well, which is to Miranda's point, maybe unlike interacting with previous types of content, the interactions of users with these is extremely legible, extremely discoverable in litigation, and therefore quite compelling in a way that, if somebody reads Catcher in the Rye and then goes and does something terrible, nobody really knows exactly what happened there. But here you have a back and forth conversation. And so I don't know how that weighs into this product liabilities conception as well, but I would love to hear more.
Yeah, I think that the interactive nature might be a quite important point, depending on how you think through things. I think there are at least 4 different questions here. One is the First Amendment at all in play? And the district judge in the Garcia v. Character AI case didn't fully resolve it, but seemed to suggest that it wasn't, or at least was at most marginally in play. I think that that's incorrect, but that still leaves some follow-up questions. One is, or let's say the second question would be, even if it is in play, can you still have a negligence lawsuit on the grounds that certain speech negligently caused harm? Could negligently cause suicide, maybe negligently informed someone how to commit a crime, or negligently misinformed the person about certain things and such. Generally speaking, the answer to that is that First Amendment often, not always, we'll get to that in a moment, but often does preclude negligence liability for speech. There have been cases, for instance, with regard to suicide, where people have committed suicide after listening. I think in one case it was, Ozzy Osbourne's song called Suicide Solution, which seemed to be much more explicitly about suicide than the conversation in this in this particular chat in the Garcia case was. And the court said, look, you can't hold publishers, you can't hold singers, you can't hold songwriters liable because some tiny fraction of the audience does bad things, whether criminal or suicidal or otherwise dangerous, based on what they are told. That's pretty well established with regard to suicide, with regard to copycat crimes and the like. So just because there's a negligence claim doesn't mean that there is that's sort of the end of a First Amendment defense. If the negligence claim is the content was what was negligent to distribute this content in this circumstance, there would be a First Amendment defense. There's a third question, which I think is somewhat potentially harder, which is, does this change when you're talking about one-on-one interactions? We do know that in some areas there is something of a change, right? If I, as a lawyer, write a newspaper column that urges certain kind of behavior and turns out probably not very good advice, I generally can't be sued for malpractice. I can't be disciplined by my state bar. There was actually a case with regard to doctors speaking out about some things regarding COVID, where the Washington Court of Appeals so held expressly, but I think it's pretty broadly understood. But when we're talking about one-to-one interactions with a client, I could be sued for malpractice. I could be disciplined. I could be punished if I'm not a member of the relevant state bar. So one question is, should we view one-to-one interactions differently? One possible answer may be only if they purport to offer, say, psychiatric advice. So only if they're actually trying to act as psychiatrists, let's say, or as lawyers or some such. But another possibility is to say, well, unlike with a song where you put it out into the world and a million people listen to it and you have no idea what their mental states are. If the chatbot, because of the interaction, actually has a good deal of data about the mental state of the listener, maybe there should be more responsibility on the chatbot creator to, for example, not distribute certain information to the person if they have reason to think the person is emotionally fragile and such. I'm not wild about that because, among other things, you then have people have the chatbots having to decide who's emotionally fragile. What if they think I'm emotionally fragile and as a result deny me all sorts of information that I feel I ought to be able to have without government intervention? But that we have to acknowledge that that's a possible distinction here. And the last distinction, which may be tied to the third one, is with regard to minors. That indeed minors do have considerable rights, including to obtain information that might be seen as dangerous. That's the violent video game case from about 15 years ago. But maybe courts might conclude that state governments, either state legislatures or maybe state tort law systems, ought to try to shield minors more as to certain kinds of things where we might think they're especially vulnerable. Again, I'm not wild about that. One can certainly see ways in which that could unduly restrict the rights of minors and of adults. But it is important to recognize that that's a possible issue there that doesn't play out with regard to a song where, could be heard by people whose age the distributor has no idea of knowing.
Right. That's all super helpful. I'd love to, now that we've sort of dug in a little bit on what the speech equities there might be. I think for my part, I think it's whatever First Amendment sections end up attaching to chatbot systems, their outputs, and courts certainly, apart from this district court, have a lot of work left to do to decide that. I think it's clear the government officials are interested in controlling the kinds of information that these chatbots provide. So, for example, we've seen the State Attorney General of Missouri alleged that failing to rank President Trump highly enough on certain metrics in a chatbot response amounted to a violation of state law. Members of Congress have sent demand letters to Elon Musk demanding that Grok never again produce certain outputs that, if spoken by a human, most of those things would almost certainly be entitled to First Amendment protection. So while the legal questions might not be settled, I think that is evidence of its own, that the government is interested in controlling speech in some way. Which brings us back to the jawboning of it all. These companies, although they are profitable and large and have an awful lot of resources at their disposal, are still under quite a bit of pressure to respond to these types of demands, whether they are through allegations of wrongdoing, whether through lawsuit or not, or sort of informal or less tangible or trackable types of government intervention and jawboning. And so I'm curious about sort of the broader environment. What types of conditions, whether it's market conditions, democratic conditions, or societal conditions, need to be in place to ensure that companies can push back against jawboning where it's inappropriate, to ensure that governments aren't able to warp the marketplace of ideas as it's mediated through AI.
Well, maybe I can jump in on that, and related to the content I had in the chat. There are some ways, and Miranda did a really good job of explaining this. There are some ways that are just easier for like quick fix ways to tweak what a model or an AI system says. And those seem to be those will be the easiest levers to pull. Those will be the ones that I think government will push the most to pull on. To mix directions, I guess there. And therefore, I would expect to see the biggest threats in that space. And so I think one way to help develop this is just really strong norms around maybe disclosures or explanations of when there are attempts to shape, say, political content that's coming out of a system. Really strong norms around that. I think it would be hard, and Eugene could talk a lot more about this. I think it'd be hard to mandate those types of conditions on such systems, but strong norms around either the right of companies to make those types of decisions, or when they do make those types of decisions to disclose them, I think could help resist or create some resistance to the otherwise quite vulnerable aspects of delivering an AI system to content moderation or content manipulation.
Yeah, and
If I could sorry, go ahead. I'll go after you, Cody.
I'll jump in. I have a little bit of a background in telecommunications, and there is a lot of ink spilled in that particular regulatory area about regulatory capture. I'm not going to give any credence to those theories, but I will say there's often instances where regulators find themselves in a position where they enjoy regulating one or two very large companies, and that gives them particular leverage. And sometimes companies are happy with that relationship as well. And I'm thinking of examples historically back to telegrams, traditional landline telephones, cable companies, and broadcast networks. And arguably, we've seen that recently under this administration as well with the Jimmy Kimmel fiasco, where he was deplatformed largely because of influence over broadcast networks and television companies who are large market players seeking regulatory approval. And AI is one potential area where it may lend itself to a natural monopoly, given the startup costs and other barriers to entry. So there might be opportunities to think about ways that we can ensure that frontier models and foundational models have an opportunity to be a more competitive market with more players that aren't as susceptible to large regulatory pressure to give into certain speech policy preferences by the regulating body.
on the competitive dynamics question, I think, enabling people to make choices based on what they're seeing across different providers is really important as well. The switching costs so far have been extremely low, but a lot of the companies now are introducing features like memory and personalization, which I think will make it maybe feel stickier for someone to stay with a particular provider. It's like OpenAI has all my context, and so it would be really hard to kind of build that back up somewhere else. So there's been some conversation around what would it look like for portability of that, but also recognizing that like that's happening. The companies are looking to make their services stickier, which, if they are sticky, then people will kind of be subject to whatever content choices are ultimately made. The value of transparency is that people would then be able to like make values-based choices of like, I'd rather engage with that AI. And so how do we just make sure that they can take action if that information is available?
If I could briefly jump in here, I agree with everything that's been said. I think transparency is clearly an enabling environment to make sure that companies do have the means to push back. But I would like to just add one more in the last, I guess, 30 seconds or so. It's accountability, right? So having that foundation of accountability, in other words, companies participating in mandatory or even voluntary risk assessments. Companies engaging with, I guess, civil society, and also companies, again, being transparent about all these activities also gives maybe, on the one hand, a chance for companies to express publicly what's happening in terms of, either official or unofficial pressures, but on the other hand, allowing other actors to also play their role, and also, in the pursuit of rights respecting sort of interventions by government in the AI space. I'll leave it there. Thanks.
Great. Well, we are at time. I want to extend my sincere thanks to our panel for joining us today. I know I learned a lot. I hope our audience did too. And with that, I will hand it back to my colleague Kate to close us out.
Thanks, Becca, and thank you, Miranda, Neil, Eugene, Cody, and Min for a fascinating discussion. And thanks to everyone who joined us today, both panelists and in the audience, and all who asked questions. Please join us again tomorrow for day 2 of the Future of Speech Online, hosted by CDT and Stand Together Trust. Again, it'll be from noon to 3 p.m. Eastern, where we will continue the conversation featuring the FTC and FCC's jawboning, the weaponization of social media monitoring to suppress speech, and we're going to hear directly from practitioners and how this moment is affecting their work and their speech. It's going to be an illuminating discussion yet again, and we hope that you will join us. Thank you so much.
Thank you.